Good morning and welcome to today's Estimates Committee hearing. I'll remind the committee that Standing Order 109 applies. If you need to interject at any point throughout the proceedings, please do so through the chair. If you wish to interject on time for opening statements, please through myself, and if I'll decide if it's getting too long, I'll let the Minister know if they can wrap up, and that's how we'll do interjections on that one. Attorney General, I welcome you and I invite you to introduce the officials accompanying you.
Thank you, Chair and the committee. I introduce Gemma Lake, the Chief Executive Officer of Attorney Generals, Leonique Schwartz, the Deputy Chief Executive Officer, Attorney Generals. I have Ben Wild, the Acting Executive Director, Legal Services of Attorney Generals, Brett Roach, the Chief Financial Officer and Senior Director, Business and Enabling Services, Attorney General, and Catherine White, Director of Crime Victim Services Unit of Attorney Generals.
Attorney General, I'll invite you to make a brief opening statement. I'll then call for questions relating to the statement. The committee will then consider any whole of government budget and fiscal strategy related questions before moving on to output specific questions. I'll invite the Shadow Minister to ask questions first, followed by committee members. Finally, other participating members may ask questions. The committee has agreed that other members may join in on a line of questioning pursued by a Shadow Minister rather than waiting for the end of the Shadow's questioning on the output. Attorney General, do you wish to make an opening statement regarding the Attorney General's Department?
Thank you, Chair. Yes, I would. So thank you to yourself, the Chair and the committee, and of course all of the officials that I have with me today. And there's a few more sitting behind me and next door in case we need to have any further detail around some of the questions. Mr. Chair, the Attorney General's Department is a diverse and complex agency. Its vision is for a safe territory supported by an accessible and fair justice system. Its purpose is to support community safety, enhance access to justice and uphold the rule of the law. It supports me as First Law Officer to government, and it provides legal services and representation to government. It administers over 150 pieces of legislation and supports the government's legislative program through review and reform. The department also supports victims of crime, ensures workplace safety and safeguards the rights and interests of Territorians through a number of independent statutory officers. The department is structured into 7 output groups. The first is legal services, which delivers legal advice to government and supports victims of crime. The second is a new group, strategic policy services, which brings together legal policy, criminal justice research, evaluation and statistics, and Aboriginal justice. The team is focused on delivering quality advice and strategic reform. The Justice Service Group supports the delivery of justice by assisting courts, tribunals and the parole board. It also manages land titles, births, deaths and marriages and the rollout of e-conveyancing. The Independent Officers Group includes statutory bodies that play a critical role in protecting community rights. NT WorkSafe is one of those officers. It's an independent regulator focused on ensuring workplaces are safe. It supports employers and workers through advice, audits, compliance and education. Our Corporate and Shared Services Group enables the entire department to function effectively and efficiently with a strong focus on streamlining and continuous improvement. While the CEO is the accountable officer under the Financial Management Act and the Public Sector Employment and Management Act, many parts of the department operate independently through statutory appointments. One example is the Director of Public Prosecutions, who provides an independent public prosecution service and supports victims and witnesses throughout the criminal justice process. Mr. Chair, there is no denying that our justice system is under immense and growing pressure. That pressure did not appear overnight. Our courts, our legal professionals and our judicial officers are dealing with increasing volume and complexity. This is a system our government is determined to reform. We were elected with a clear platform: reduce crime, rebuild the economy and restore our lifestyle. And we are getting on with the job. Since being elected in August, we've taken real action. In the criminal justice space, we introduced Declan's Law, a presumption against bail for serious violent offenders, broader definitions of offensive weapons and expanded electronic monitoring. I'd like to acknowledge the fierce advocacy of Samara Laverty, Declan's mother, who was present in the chamber when these landmark laws passed. We introduced mandatory minimum sentences for assaults against workers, including police and emergency personnel. We reduced the minimum age of criminal responsibility to 10. We created new offences for ram raids and for boasting about crime on social media. We strengthened domestic violence laws to include mandatory sentencing for certain DVO breaches and expanded the Victims Register as a first step to addressing the horrific rates of domestic violence across the Territory. We increased the Victims Levy by 40%, ensuring there is more money available to support victims' services and their supports. We classified the highly potent drug fentanyl as a Schedule 1 dangerous drug, ensuring much stronger penalties apply for its possession, sale and supply. And following a tragic incident, we recalled Parliament urgently to introduce and pass the strongest bail laws in the nation. This Act introduced a new two-step test for bail. It makes community safety the paramount consideration, and a person cannot be granted bail unless there is a high degree of confidence that they will not reoffend or endanger the community. In the court system, we lifted the Darwin Local Court prisoner cap, enabling more bail and arrest matters to be heard daily. In the wider legal space, we supported the rollout of e-conveyancing through legal reform, which will introduce a modernised digital process to streamline property transactions and cut unnecessary paperwork for those purchasing a property. We reformed healthcare decision-making by allowing senior practitioners to delegate their functions to appropriate staff to ensure timely and appropriate care of people with impaired decision-making capacity. We introduced important changes to the Crime Victims Services Unit so that more assessors could be made available to reduce backlogs in victims' claims. We are delivering on our commitment to restore fairness and common sense to the anti-discrimination laws. The 2022 changes went too far. We are removing unclear terms like offend and insult and replacing these with a much clearer standard, one that already exists in other parts of Australia. Our reversed law will prohibit conduct that incites hatred, serious contempt or severe ridicule based on personal attributes like race, sexuality, gender identity, religion and more. We're also restoring protections for religious schools, allowing them to hire staff who uphold their faith, while still maintaining strong protections against discrimination based on race, sexuality or gender. These changes reflect our belief in free expression, religious freedom and fairness to all. We consulted widely and carefully to get the balance right, and the bill will be introduced in the July sittings. Just as we're restoring balance in our laws, we're also standing up for Territory traditions and lifestyle. Mr Chair, thanks to the strong advocacy of our Chief Minister with the Premiers of New South Wales and Queensland, we were able to cut through layers of red tape that almost extinguished our Territory Day fireworks celebrating self-government. Our team at NT WorkSafe were on the ground to ensure nearly 100 tonnes of fireworks, which had been seized, were released and transported through to the Northern Territory, saving Territory Day. Mr Chair, in legal aid, we secured a multi-year funding agreement which includes an increase of $3.5 million in the 2024-2025 budget and $5.5 million each year ongoing from 2025 to 2026, which represents a roughly 80% increase in previous baseline funding. We also selected a new director who will assist in vital change management in Legal Aid NT. We established a Legal Aid Sustainability Committee for the purpose of providing direction and oversight on much-needed reform in the organisation. Legal Aid is a critical organisation to ensure everyone has an opportunity to have legal representation and in particular to ensure justice for victims. We're backing reform with investment. This budget commits a record $1.5 billion to address law and order. We're developing a reducing crime strategy focused on prevention, accountability and consequences. Because keeping our community safe is not just about strong laws, it's about ensuring the entire system works, from early intervention through to sentencing and rehabilitation. We are also taking real steps to strengthen the justice system itself. We've secured funding for an additional local court judge, the largest ever judicial complement in the Territory. We are increasing the number of prosecutors and support staff and converting temporary contracts at the DPP into permanent positions for the first time, giving staff certainty and giving the system stability. And we've introduced the DPP's Targeted Intervention Group Early Resolution Task Force, or Tiger Team as we call it. This team has already resolved over 200 cases, restoring accountability, reducing court backlogs and improving efficiency. And even more importantly, engaging victims earlier in the process. As we have said, this is not a set and forget approach. There is much more to do, and we are getting on with the job. Violence continues to be an unacceptable problem in our community, including domestic violence, and we will continue to strengthen the laws into the future as we reduce crime. We will not accept the status quo. We will reform, innovate and reprioritise to deliver a better justice system for Territorians. I acknowledge and thank the department officers who are here with me today, those behind the scenes for all of the work that they have done to prepare for this hearing. Thank you, Chair, and I welcome the committee's questions.
Thank you, Attorney General. Are there any questions on the statement? Shadow Minister, Member for Yingiya.
Thank you, Mr. Chair. Attorney, in your opening statement, you spoke about your changes to the Northern Territory anti-discrimination legislation. Attorney General, can you outline or explain the legal policy rationale behind your government's decision to water down the anti-vilification provisions in Section 20A of the Act?
Thank you, Member for Yingiya. So, as we have spoken about for quite some time now, we are moving to restore the balance of our anti-discrimination laws. And after consulting widely with what the community is looking for, we have come up with this position of a balanced approach. I reject the claim that it's watering it down, because it, in fact, by removing the words offence, insult, humiliate or intimidate and replacing those with words such as incite, hatred, serious contempt or severe ridicule, it actually means that those are the things that we as a community won't accept, and that those people that do that will be held to account, and that there will be consequences for that kind of speech, because everybody deserves to feel safe in the community and feel like they belong. And yet at the same time, we also have those territory freedoms that we can actually enjoy each other's company, go to multicultural events and enjoy what it is the Territory has to offer. I mean, that's a huge part of our story. We want our faith groups to be able to practice their religions with their freedom of speech without being persecuted in case they say something in line with their belief that offends somebody else, which of course is a very subjective, overreaching word to use if you end up in courts and somebody else is the one that determines whether they are offended or not. And so we believe that by changing these words, not only other Australian jurisdictions are doing this, but the fact that we now have protections for people who, you know, we don't want that hate speech going around, but at the same time, we also want that freedom to be able to be Territorians and enjoy the Territory lifestyle that we have.
So I just wanted to pick up, you've talked about needing to restore an imbalance. What is that imbalance?
So, Member for 𝙍𝙀𝙇𝙀𝙎, thank you for the question. The laws which were introduced in 2022 had the Section 20A in there, which had the words offend, insult, humiliate or intimidate, which meant that if you were to feel that those things had happened, you could be before a hearing with the Anti-Discrimination Commissioner. And we know
and
that we've
think that's a bad thing?
We know that we've had complaints that have been brought forward in that space, and the Anti-Discrimination Commissioner has been dealing with those. But we didn't want to remove that altogether after consultation with the community, because we do have lots of different groups throughout our community that feel that sometimes there are people who say really awful things to them, and we didn't want them to feel like they were having that kind of attack on them. And of course, we've seen around Australia and the world that hate speech, which we don't stand for at all. So instead of repealing the whole section, which we believed the word offend was such a broad, overreaching word and subjective, we have decided to replace those words with the new words which do rule out those awful things that people can say about other people, being incite, hatred, serious contempt or severe ridicule. What doesn't change, Member for 𝙍𝙀𝙇𝙀𝙀,
So do you feel it's okay for people to be offended? Because you're removing that provision, is what you've just, your very own words.
I will. Sorry, Minister. As we're well established, if you wish to interject through the Minister's answer, please come through the chair. Minister.
Thank you. What doesn't change in our Act is the fact that it is still illegal to discriminate. You can't discriminate against someone based on their gender, their race, their sexual orientation, or a bunch of other things. And there's quite an extensive list in the Act of the things that you cannot discriminate against when it comes to
through the chair,
So
the question is, through the chair, members of this committee and yourself often use standing orders when you are offended at something, but can you confirm that your government is removing the provision of someone being offended about a racial slur or a homophobic slur or a discriminatory remark because they don't feel that some people should be offended?
Like I was saying,
Well, you haven't answered the question through the chair.
Like I was saying, Mr. Chair, we are replacing the words offend, insult, humiliate or intimidate with much stronger words, because we don't stand for the kind of hatred, hate speech that's out there, and which is why we've made it incite hatred, serious contempt, I should say, and severe ridicule, because it's a balance of the freedoms of expression, of speech. We still want to be able to tell a joke. We still want to have good freedom of speech debates.
Shouldn't come at the cost of offending, though, someone through the chair. I'm going through the chair.
Yeah. Member for 𝙍𝙀𝙍. Thank you, Member for Daly. Member for 𝙍𝙀𝙍. Please let the Attorney-General finish her answer. If it's unsatisfactory, then you can re-ask the question.
Well, I will re-ask it.
Attorney-General.
Thank you, Mr. Chair. The word offend is a subjective word. just because I feel offended by something, it doesn't mean that you might be offended or vice versa. What we're saying is that we don't want people going around and discriminating, which is illegal, and that's very clear in the Act. And we don't want people going around inciting hatred, severely ridiculing somebody, or treating someone with serious contempt. And so those words are quite appropriate to have in the Act to ensure that people can still have those freedoms, and that if someone feels offended, then they can speak to each other about that. We live in a democratic society where we should be able to have freedoms of speech, but what we don't want is for that hatred to be incited, which is why we're making these changes.
So through the chair, we are seeing an increase and a rising across this country around, racial division, anti-Semitism, homophobia, people constantly being offended. You've spoken now about you've done extensive consultation and you have resolved to remove, offend and bring in additional terminology. Who have you consulted on this?
Thank you for the question, Member for 𝙍𝙀𝙇𝙬𝙎. So we've held roundtables with different religious groups. We've spoken to multicultural groups, the 𝙍𝙬𝙬𝙬𝙬𝙬+ groups, the sex worker industry, the HIV, hepatitis industry, and the Anti-Discrimination Commissioner as well. We've had several meetings with him about the types of things he's seeing. Originally, we'd said before the election and at the time of those 2022 changes that we would remove the word offend because it was an overreach and removing the rights of freedom of speech.
And through the
but
chair,
in consulting
Attorney,
with those
through the
groups,
chair, I just want to be clear. I'm also after what your definition is of consult, because going and meeting with an organisation is not consultation. I want to know what you were consulting on and what did you take to them to discuss?
Thank you for the question, Member for 𝙍𝙬𝙬𝙬. So the conversations we had were very specifically around the proposed changes that we were making based on the 2022 changes that the previous government brought in. Because, like I said, before the election and at that time, we had said that we would, and we used the words reignite the flames of freedom, to be able to ensure that we had the right balance of protecting those against that kind of vilification, but also ensuring that freedom of speech. And so by going out to those groups and sitting down very specifically talking about the vilification clause, that's section 20A, we sat down and they gave me all of the feedback about what they experienced in their groups, the things that they were concerned about, the fact that if we were to do a straightforward removal, then that could open up that kind of hate speech, which we don't accept as a community or as a government. And so in going around and speaking to all of those people, working with the Anti-Discrimination Commissioner, we decided to make those changes to say, well, we will remove the word offend because that is an overreach and doesn't allow for that democratic community that we know we have, but we would include and continue that vilification. And in fact, we've strengthened it by really drawing a line in the sand, saying we don't accept the hate speech, we don't accept severe ridicule and serious contempt.
So many of the organisations that you claim to have consulted with have raised significant concerns and have said that they are opposed to the changes that you're making. I just want to be clear, there are currently 20 attributes in the Northern Territory Anti-Discrimination Act which are protected. You put a press release out yesterday and you named a number of them and then you said, and more. What are the attributes that are going to remain in the bill and what are the attributes that you are removing?
So the Member for 𝙍𝙬𝙬𝙬, thank you for the question. We're actually not removing any of the attributes from that previous section. The thing that is changing is section 20A, and we're replacing the words, like I said before, offend, insult, intimidate and humiliate with the new definition of incite hatred, severe ridicule and serious contempt. Sorry, it's actually the other, not in that order specifically,
so
but you know what I mean.
You are going to retain the 20 attributes?
Yeah, all of those 20 attributes are retained.
question.
Member for
Through
Johnston.
the chair, thank you. Two quick follow-up questions. So one was just in relation to consultation, just wondering whether any of those groups were provided with the bill.
So nobody has been provided with the bill yet. That is still being drafted. I wanted to ensure that there was plenty of time for people to see the types of changes we're making, because like I said, in 2022, we've gone out to the community to say that if we were elected, that we would restore those protections we would reignite those flames of freedom of speech. So that bill is now being prepared and it will be tabled in Parliament, introduced in Parliament in the July sittings for debate in, I guess, September. That would be the next sitting day. And of course, my office is always open to have further feedback, but I think in the last few months, in consulting with a wide range of people across our community, including the Anti-Discrimination Commissioner, it was really clear to me that we didn't want to remove the vilification clause altogether because that would have an unintended consequence. We wanted to ensure that it would just find that right balance, and like I said, that's why we're replacing the words that are there now with the new words.
So the Anti-Discrimination Commissioner hasn't seen the bill?
So the Parliamentary Council does work in consultation with the Anti-Discrimination Commissioner, and that work's underway now.
Okay, so he has seen the bill, or?
Well, the bill's not created yet. The OCP are going through that now. What we have worked with the Anti-Discrimination Commissioner is a lot of that consultation. He brought his concerns about what he's hearing in the community about that, and
He would have seen a draft, though.
yeah, apologies. I've just been told there was a draft originally that he has looked at.
Is that the draft that you're referencing in your op-ed yesterday and in what you're saying this morning?
Yeah, that's right.
Thank you.
Thank you.
Can I also ask so one of the changes is that you're now using the word incite. Can you just, for clarity, explain what that actually means?
So obviously we want it to be a balance of, it's not just having a joke at the pub that's going to land you in front of a hearing. We want something that's more serious than that. And of course, any kind of hate speech is not acceptable in our community. And so ensuring that that's the case
Unless
by
it's at a
inserting
barbecue,
those words,
sure. Yeah.
then that then allows for, a case to be heard.
So incite, just for a sort of plain English definition of incite, what would that mean? What does that look like? What would pass that bar?
I guess it would be based on case law and other things around the country. This is the same language that has been used in other bills around the country in other states. And so there would be a number of case law around that. And I think the Anti-Discrimination Commissioner did touch on that when we're having consultation. But I think the fact is that we're retaining that vilification line to ensure that we don't have those kind of hate crimes or speeches, if you like, out there in the community, and that we believe that this balance will make sure that's really clear to everybody.
Thank you. So I'm still unclear about what incite might mean. I know that's a question that people have asked me to raise, so I wonder if you're not able to provide a clear definition now, if you could take that on notice.
Yeah.
Or
I guess someone that could probably do that quite well is the Anti-Discrimination Commissioner, and he will be before the hearing.
Against that output. Thank you.
Just because of that experience that he has had with the clause and how it's been operating since 2022. I just don't want to go down into any hypotheticals.
So through the chair...
Attorney, so apologies, Member for Gurja. Member for Johnston, did you want anything on notice, or are you happy
I'm happy to wait for that output. Oh, actually, maybe just in case we don't get there for some reason, could I put that question on notice?
Yes.
Thank you,
Well,
Chair.
it'll be up to the Attorney General. Member for Johnston, please restate the question for the record.
Could you please provide a definition of incite under the proposed changes to the Anti-Discrimination Act?
Attorney General, do you accept the question?
I do, Chair. Thank you.
The question asked by the member for Johnston of the Attorney General has been allocated the number 5.1. Follow-up question, Member for Nightcliff.
Thank you very much. Just to follow up from that line of questioning. So So as I understand it, we're not removing the whole of 20A. We're just changing, replacing those words offend, insult and humiliate with the other ones you've listed. Isn't it true, though, that the idea of it, people being offended and it being illegal in like a backyard barbecue making a joke, isn't that not correct because this has to be in public, right? It doesn't count. You can't use this in public places.
I guess that's part of the subjective nature of the way that it is now. And we've seen cases where the complaints have been made and then basically dismissed straight away because, it may not meet that particular threshold. However, we're really wanting to bring back that balance to ensure that people know wholeheartedly that freedom of speech is good. We want that in a democracy, that people of faith can practice their religion without the fear of ending up in a hearing. And so we've created the change so that it's not just about the subjective word of offence, which really it could be anything, anywhere. So by making it really clear that you do have to incite that hatred or there's other things, then that's when, something more serious needs to be answered to.
Sure, but I mean, through the chair, the idea that the sort of the narrative that we've been hearing from the government around the fact that the old provisions were making it illegal and, to make jokes at a family barbecue. It's not actually true, though, is it? Because things said in private don't come under this.
Well, and I guess that's part of it. Thank you for the question, Member for Nightcliff, is that it is so subjective that potentially we could have a lot of people running around feeling like they are offended based on just everyday conversations. And
that's what I'm saying.
What's the definition?
They can't, though, in everyday conversations because
no,
private
there's a
conversations.
higher bar.
It's a much higher bar than that is what I'm trying to get at, right? So that idea is not correct.
So, Member for Nightcliff.
Correct?
Member for Nightcliff. We will let the Attorney General finish her question. If you are unhappy at any point, please just tell me the issue and I'll go from there. Member for Nightcliff.
Oh, okay. I understand you keep sort of singling out the word offend, but isn't insult and humiliate, I mean, do you believe it is okay for people to publicly insult and humiliate people based on characteristics such as sexuality and race and gender?
Thank you for the question, Member for Nightcliff. I'm not going to put forward my personal opinions because that's not the way to do this particular hearing. But like I have said, this is about restoring the balance of protections as next to freedom of speech. And the consultation that we had across a lot of people, I actually do have a list of all of the people here if you want to know who they are. But we just wanted to make sure we got that balance right. So by changing those couple of words, which is in line with other jurisdictions around Australia, we feel that we struck that balance.
So through the chair, just to be clear, there are actually provisions already in Section 20A that protect freedom of speech. So the assumption that there are not is misleading. Furthermore, how many complaints are you aware of the Northern Territory Attorney General that have been dealt with by the Commission around vilification?
I will probably wait for the Anti-Discrimination Commissioner.
But you would have a number of the amount.
Say exactly what they are, because I guess it's the way that he assesses those is, there's a certain number that come in and then he assesses them based on where they go, whether they're dismissed straight away or whether there's a further meeting or further information gathered, or whether they've gone into court or not. And that specific number I don't have. However, in the conversations I have had with the Anti-Discrimination Commissioner, my understanding is in the last 12 months there were 40 complaints of, in line with that 20A section of the Act. But like I said, I might get him to add further to that when he's at the table with me.
Sure. So through the chair,
Member for Guyula, I will just allow the member for Nightcliff to finish her line of question, and then we will come back to you as Shadow Minister.
Sorry, Shadow Minister. Just a final question. Are you able? You said you had the list there. Are you able to tell me how many times your department have met with the Australian Christian Lobby or their representatives?
So I have met with the Australian Christian Lobby Group officially once. And I think I may have spoken to them on the phone once. But should I throw to the CEO? Did you have any detail about any meetings you've had with groups? Okay. Yeah, the department hasn't met with that group.
Okay, thank you.
Shadow Minister.
Thank you, Mr. Chair. Following on from that, you were talking about consultation and working with the Northern Territory Anti-Discrimination Commissioner regarding the impacts or the changes of the vilification provision. Can you table that advice from the Northern Territory Anti-Discrimination Commissioner?
Sorry, can you just, are you asking me to table information that the Anti-Discrimination Commissioner has...
You've said in your response that you've met with the Commissioner, you've spoken to him about the changes as you have with other people. Are you able to provide what the Commissioner's response was for your legislative changes?
So the conversations I've had with the Anti-Discrimination Commissioner around this particular section was like a face-to-face meeting. I would need to double check to see if I have anything on file in writing about that. But in any case, that's more of an internal documentation. I mean, he is an independent statutory body. I guess if he would like to table or make that public himself, that's a matter for him. But yeah, those conversations that we've had were in face-to-face meetings about it.
Great. And just following on, you spoke about the religious exemptions, and there has always been an inherent requirement for particular positions within a faith-based organisation or school. We understand that that will be removed with your changes. But to your knowledge as the Attorney-General responsible for this carriage of legislation, are you aware of any cases where there has been a matter before the Anti-Discrimination Commissioner because of these changes?
Just while I'm waiting for some extra advice so I can get that right for you, Member for 𝙍𝙀𝙇𝙬𝙎, can I just clarify, maybe it was the Member for Johnson who asked, just wanted to clarify that the Anti-Discrimination Commissioner did see an earlier draft of that bill, but that he has not seen the very latest draft. Like I said, we'd gone through a process of looking at all the different things we wanted to change about it, and so he has not seen that very final version yet.
So you haven't had any feedback from him on the final version?
No, so when we catch up, meet face-to-face, we'll be able to talk through that, but well before it's introduced.
Thank you.
Going back to the question about if those any complaints have been received about the religious section of the Act, I will need to defer that question, if it's okay, to the output when the Anti-Discrimination Commissioner is here before me, and that way he'll have all that information.
Or perhaps if we don't get there, you may take it on notice now.
I'm happy to take it on notice now in case we don't get there.
Member for 𝙍𝙀𝙇𝙬𝙎, please restate the question for the record.
Thank you, Mr. Chair. Attorney General, are you able to provide the number, if any, of any matters that have come before the Anti-Discrimination Commission as a result of the 2022 anti-discrimination reform when it comes to the religious exemption?
Minister, do you accept the question?
I do.
The question asked by the member for 𝙍𝙀𝙑𝙬𝙎 of the Attorney General has been allocated the number 5.2. Member for 𝙍𝙀𝙑𝙬.
Thank
Can I
you.
ask a quick follow-up to that? Thank you. Which you may also ask that Anti-Discrimination Commissioner to answer. But is there any evidence that you've been provided by the Anti-Discrimination Commission or any other bodies that religious education institutions, faith practices have been impacted by 𝙍𝙬𝙬𝙬𝙬𝙬+ teachers or students since the repeal of the former Section 78A?
I think I will defer that to when he's here at the table, because he could definitely add more about the information that he has at hand.
Okay. Just interested in what evidence you're basing that repeal on. Do you have any of that information?
So that particular section of the Act, we were very clear before the election and in 2022. We had all the faith leaders and community at the front of Parliament House when those laws were introduced and when those protections were taken away, because they felt like they were leaving themselves open to, hearings and court cases, and if they didn't have the protection in place, that they could actually employ staff who have their faith, so they can continue their teachings. And so we made it clear to the community at that time that we would in fact put those protections back in place. I guess the final part of the bill for the old 37A, which we're calling a new section now, it's not quite the same. The old section referred to not being able to, or being protected from discriminating against sexuality as an example. One example, we've removed the fact that you still can't discriminate against attribute in the new section, but that you can employ based on the same faith that they have, and that's to ensure obviously they can continue those teachings, but that they can also, in line with their policies and Fair Work, they can't discriminate against the attribute. It would always be about the conduct, because then that would be in line with the faith.
Sure, thank you. And I understand the political background to this. My question more is about, is there any evidence that there has been any negative impact on faith-based institutions? So I'm happy to ask further of the Anti-Discrimination Commissioner if you don't have that information.
Yeah, I think the anti-discrimination can certainly help with the feedback that he has had in those last couple of years when the new Act was in force.
And is that feedback that you have taken into account as a government in terms of making law?
That's correct. So basically the conversations I've had with the Anti-Discrimination Commissioner, a lot of the community groups across the territory about that particular 37A, which is the protection of religious freedoms, and being able to employ based on faith, that not only were we consulting back then in 2022 and made that decision to repeal that part of the bill and make sure those protections were in place, but then a few years later and now being in government, we've looked at that particular clause that was removed, and we've recreated a new section which allows for them to continue to employ based on faith, and of course keep those protections for people, so they still can't discriminate, but they can employ based on faith.
Thank you, Attorney General. I think I understand the context. I'm still really interested in whether or not there's been any examples of any negative impact on faith-based institutions.
And I'm sure the Anti-Discrimination Commissioner can help with that.
Through the chair, can the Attorney General or the department provide advice on where they got the evidence form to drive all of the changes with the Anti-Discrimination Act?
Thank you, Member for 𝙍𝙀𝙇𝙀𝙎. Like I said, this was an election commitment, so we said we would go through this process to reignite the flames of freedom, as I said, and talk about that, restoring the balance of freedoms but also protections. So we started working through that information. We went around to other jurisdictions around the country. We spoke to many groups to find out the things that they wanted to see in the changes, based on their lived experience and their concerns over the last couple of years. And I think we've got now a balance where those faith-based schools are protected, so they can continue their faith, and yet people can still be protected in the terms of the vilification, because we don't stand for that type of hate speech. So there is that balance about it.
Through the chair, I appreciate the story, but again, this sounds like there's not an evidence-based approach, because you're obviously made a commitment during an election, but there's no hard data to inform that these changes are addressing an issue that was there, because we don't know how many matters were before the Commission, and we don't know how many matters this will potentially resolve. So I guess I appreciate that, but you're not able to provide us with any hard data or numbers that say this will change, this will have an effect here.
Yeah, and I've said a couple of times, I am happy to take those questions when I do have the Anti-Discrimination Commissioner as well with me, because he does have that data and information at hand. I just don't have it right here.
For all intents and purposes, through the chair, the Anti-Discrimination Commissioner is a statutory authority who provides advice to government when required. So clearly the government, which is you, has had to identify that there was an issue, look at the data, look at the evidence and make a change. Where is the data? Where is the evidence that you are using to help you make an educated decision?
The evidence that I have is there is evidence from the Anti-Discrimination Commissioner. I said we'd get to that when he is with me. He has the data of those complaints that have been made. I don't have them right here on me. I don't have them inside my head.
But through the chair, that data
Member for Guyula, please.
is not. You're making the assumption that
Member for
data is
Guyula,
negative.
Member for Guyula. We'll let the Attorney General finish, as we had last week. If you think your question's not been answered, please tell me, and then I'll address the.
My question's
Attorney
not been
General.
answered.
Okay, Attorney General, could you please restate the question, Member for Guyula?
So my question is to the Attorney General. You make changes based on, well, a good government, I'll rephrase that, a good government makes changes based on evidence, data, sets that help inform them to provide better protections for Territorians. Now, the Attorney General has said that there are matters before the Anti-Discrimination Commission. We will ask him what the nature is of those, because just because there's a matter before the Commission doesn't mean it's bad. It's actually a good thing because someone is seeking support for a protected attribute to be supported and recognised. What I'm asking the Attorney General is, what data does the department have that has informed these changes? Because there are already 20A has religious. It has protections of freedom. So what has driven you to make these changes other than a commitment to the Australian Christian lobby?
Yeah. Can I just clarify or be clear that we're not changing the attributes of discrimination? It will still be illegal, as per the Act, to discriminate against those attributes. What we're doing is putting in place some protection mechanisms for, one, the faith-based schools to continue their teachings, and two, the protections of people so that they are not experiencing that hateful speech and that ridicule. The consultation that we did are the real-life cases of people explaining to me how those things impact them, and that includes the religious schools who talked about their worries with what's happening, and also the other groups when it comes to vilification and the examples that they gave me about that. I mean, that there in itself is evidence, and that's on the back of an election commitment that we made to ensure that we would make these changes. So I don't apologise for making the changes. I think that, you know, we were elected on by a majority to make changes to the Northern Territory. This forms part of that, and I've been upfront with Territorians. I think I've even demonstrated the fact that we were able to come up with a compromise of those protections to ensure that people do still feel protected and that we aren't going to stand for that kind of hate speech. But at the same time, we're not going to move away from the freedoms that make the Territory so special and our freedom to live in that multicultural society. And we have so many people from so many places, which is amazing. And so I stand by the decisions I've made there. We have made those adjustments along the way to meet the evidence we've received from the community. And I really look forward to introducing this in July and hearing from our community as to what they think. I think that once they understand that we have remained true to those protections so that they are not feeling like they're open to that kind of hate, then that would be something that would be welcomed.
So through the chair, how will the government manage with these changes and removing the word offend or offence? We are obviously in a changing environment where people are making, neo-Nazi comments referring to, whether it's the survival of the fittest or so forth in social media. How are we going to provide that protection for our multicultural communities, our Aboriginal Territorians, our rainbow community, when offending offensive language can have a significant impact on people's social and emotional well-being?
Thank you for the question, Member for 𝙍𝙀𝙇𝙀𝙎. And I guess your point is that that's why we're keeping the vilification laws there, and that's why we're changing the way in which the wording is, because
But you're getting rid of the word offence.
because offensive is a subjective term. I might be offended by this glass of water, but you're not. And somebody, if I get offended and
That was
say
the most stupidest thing I've ever heard come out of an attorney's mouth. Honest to God.
𝙍𝙀𝙇𝙀𝙎, okay. To start with, that was an insult. I'm not going to put you on a warning. However, Member for Daly, this isn't for you to chime in. You're not being on a warning, but if we can...
I'll rephrase. I will
Thank you.
rephrase. Is it not the role of the Anti-Discrimination Commission to determine whether or not, if someone lodges a complaint about being offended, for them to investigate and make the determination?
Yes, and he will continue to have a role to play with the Act because it'll be his Act, and the new Section 20A is still very robust. It still has all the mechanisms in place to be able for someone to come forward if they feel that what has been said to them or about them is in line with the description of the Act, and of course that will take its course. I see that it's still a strong measure of anti-vilification, so we don't put up with that kind of behaviour, but at the same time we still can have a conversation, have a debate, tell a joke, practice our faith in our churches without having to worry about somebody feeling offended by a statement or a word.
So just to pick up through the Chair, you also spoke about consulting. Did you take a draft bill to consult with all of the organisations that you say you've consulted with, or was it just the Anti-Discrimination Commission?
So the Anti-Discrimination Commission had seen the original draft bill and it changed. Oh, yeah. And so my understanding is that OCP provided the draft bill and the department also consulted with him about it. With the individual groups, because you need to get the sign-off before you can consult with the very specifics of the bill. And, of course, we went out after the election and started those conversations based on the set of ideas that we'd originally had before the election.
Sure. So, Attorney, the question is, when you went to do consultation, did you take a draft bill to, NTARC, the Sex Worker Alliance, the Australian Christian Lobby? Did you take a draft bill, or was it just consultation as in a discussion?
Yeah, so the meetings I had were discussions, with lots of feedback coming my way. It was really open in the fact that I said, look, tell me exactly what it is you're looking for.
Yep.
Of course, they had other suggestions to improve it even further, which is different sections.
Thank you. I appreciate that. Attorney, we asked this question to the Chief Minister, and she handballed it to you. Is the CLP government honouring the $300,000 funding commitment made by the previous government to conduct a racism review in the Northern Territory Police Force?
Thank you for the question, Member for 𝙍𝙀𝙍𝙍. So the previous Labor government committed to conducting the systemic racism reviews across all NT government agencies, and that was under the Aboriginal Justice Agreement. But in that 3 years after that was announced, only one agency had started, and I believe that review is still not even finalised. In fact, I think it was yourself that said that you were I'm very confident that we will be able to roll out the review and have done that in a prompt manner, but we hadn't seen anything further since that comment.
Well, you've been in for 9 months. Where is it?
So,
Committee, again, always just tell me if you feel your question's been answered, if you feel it's not being answered, if you'd like to make further comment.
Through the
please
chair,
tell me
I don't feel
what the
my
issue is.
question's been answered. I asked the Attorney-General, where is the commitment of the $300,000 to do the racism review into the Northern Territory Police Force?
Thank you, Member for Guyula, Attorney-General.
Thank you, Chair, and thank you, Member for Guyula. So upon coming to government and looking at all of the funds that we didn't have in the budget and to be able to spend on, we had to look at all those areas in quite detail. And after assessing where we were at with, especially in the Attorney General's department,
Through the
you may
chair,
remember that we had
is there or isn't there? That's all. Like, it's a yes or no.
So the $300,000 that was committed by the previous Labor government to do the racism review, we had to redirect that fund to Legal Aid NT
So there
to
is,
keep them
through the
sustainable.
chair,
Because you will remember
there's no
that
review into the racism now.
I will let the Attorney General finish. Once she's finished, it'll be the member for Guyula's question. Attorney General.
Thank you. I wanted to make it really clear, Mr. Chair, that the $300,000 was redirected from the review that was the Anti-Discrimination Commission that was going to do that to Legal Aid NT. And as people may remember, at the end of last year when NARJA were having those problems, they couldn't take on those new clients. They had to stop some services. Legal Aid had to take on those clients, and it was really important that Legal Aid had the funding that they needed to continue the work so that we did have representation in our courts for those people. And so that money is now with Legal Aid, and it has been removed from the racism review under the Anti-Discrimination Commissioner.
So through the chair, the Northern Territory Aboriginal Justice Agreement, wonderful agreement. Hope you've read the agreement. Your government say you're committing to the agreement. Your actions speak louder than your commitments, because can you confirm now that there will be a racism review into the Northern Territory Police Force and other government departments? And if so, when?
Thank you for the question, Member for Guyula. Obviously, that particular question is the police review. It is work the police are doing, and we have, I think
So, Attorney General,
chiefs,
through the
I can't
chair,
remember who's mentioned it in the previous
through the chair,
day, but
you're
Leanne
suggesting
Little's
that
now
police
working
are going
with
to
the police.
Member for Guyula, please, we'll let the Attorney General finish, and then you will have the floor. Attorney General.
Yeah, I don't want to speak on behalf of police, but I do have the information that work is being led by Leanne Little, who works in that department now, covering a broad range of initiatives. I also understand that the full implementation of the 𝙍𝙀𝙇𝙀𝙍𝙍 coronial, there was a bit of a hold up waiting for that because there was some things out of that they wanted to implement in police. But like I said, I don't really want to talk about what the police are doing, only because it doesn't sit in my portfolio. But what I can confirm for you under my portfolio is that the $300,000 that was committed by the previous government to the Anti-Discrimination Commissioner to do a review into that police was not able to be given to them, that $300,000, and it's now been given to Legal Aid to ensure that they could continue their delivery of service, because we have this huge court backlog. We need defendants and offenders to be represented by legal services, and it was a really tough decision, Mr. Chair, that we had to make at the end of last year to find that money somewhere. I mean, there was literally no buckets of money available to the government to be able to give Legal Aid that money. We had to make that tough decision, and I'm glad we did, because we have been able to make some small incremental inroads into the court system with that money, that $300,000 that Legal Aid got, because they have been able to continue that work. And even 𝙍𝙀𝙇𝙀𝙀 now is starting to get back on its feet. They've made a lot of internal changes, and they are taking on clients, so that people are being represented right across the territory. And I think it's so important that you have those two bodies that do such an important work in our community to have that funding. So it's just so much easier.
Through the chair, I've asked the Attorney General for a very direct question. Attorney General, you're suggesting now that police are reviewing themselves about racism in the police force? That's what you've said. So I don't want to verbal you, but I want to know, you just have said that the Anti-Discrimination Commission are not going to conduct the racism review, that is being done inside police, by police. So can you confirm, will there still be a process under the Aboriginal Justice Agreement, which is not in police, to review the Northern Territory Police and other government departments?
So, Mr. Chair, under the Aboriginal Justice Agreement, there is work being done on an anti-racism strategy. However, that work is underway in that unit. We will have Mr. Pocock coming in later today under the Aboriginal Justice Unit, who can probably answer extra questions about the operations and the work that's been done in that space. Like I said, I just wanted to confirm with you the direct question, the fact that we did not have that money to be able to use.
You've already said that review is not happening, but I'm asking, as far as you have been advised, police are reviewing police about racism.
My understanding is I don't want to speak on behalf of police.
Well, you're not.
I don't have that.
You're just providing your understanding.
We'll let the Attorney General finish. Once the Attorney General's finished the answer, we will go to a break. Whilst the Attorney General's getting advice, I'll also just remind the committee there'll be no hears or shames from the committee. Attorney General.
There hasn't been any.
Not from you.
Well, not from me.
I think I've answered the question, though, unless there's another question you had.
No, look, that's... So I guess what I'm trying to understand, Attorney, is there was a review in place. The Anti-Discrimination Commission accepted to take that work on. There was a funding arrangement with AGD and with police. I'm just simply asking, to your knowledge, I'm not asking you to speak on behalf of the police, but to your knowledge, police will be reviewing police around racism in the police force?
To my knowledge, there's a anti-racism strategy that police are working on.
Can I ask one little follow-up question to that, Chair, before we...
We'll give... The member for Johnston can ask one follow-up and then we'll go to a break.
So just in relation to the what the member for Guyula referenced in terms of the AJA's commitment to identify and eliminate systemic racism in government agencies, I know that in the implementation plan there was a target of 10 reviews of government agencies, one of which was police, which we've heard about. I heard you say that we'll be able to ask Mr. Pocock more detail about that. Are you able to give any sense of whether any of those reviews are being progressed?
Thank you, Member for Johnston. There was work being done prior to the election, is what I'm advised. Obviously, I wasn't the minister then. And think that's the first agency they had chosen prior to the election was the Department of Infrastructure, Planning and Logistics.
Yes.
Yet that work was paused during the caretaker mode, and of course the department then, with the MOG changes, machinery of government changes after the election, it meant that that work was being done first to be able to work out what was next. But I guess any further specific questions about when that may progress under the Aboriginal Justice Agreement and the unit that sits around implementing that. Mr Pocock will be here and he'll have some more operational of where they're sitting with those reviews if you'd like to ask him.
Thank you. So to your knowledge, the DIPA review has been paused and sitting somewhere, and none of the others, to your knowledge, have commenced. Is that correct?
That's my understanding.
Thank you.
Yeah.
The time now is 10:06. Committee will break for 5 minutes, reconvening at 10:11. Okay, time now is 10:13. We had to do a bit of rearranging, which took just an extra 2 minutes. But I'll now hand over to Member for 𝙍𝙀𝙇𝙀𝙬.
Thank you. Attorney General, can you please confirm if there has been a funding cut to the Aboriginal Justice Agreement by $4 million? While they're finding that through the chair, might I just acknowledge that the member for Drysdale's mum is up the back there watching the chair do the hard job. Welcome to Parliament House.
Thank you, Member for 𝙍𝙀𝙇𝙀𝙀, and hi, Mum.
Thank you for the question, Member for 𝙍𝙀𝙀𝙀. So under the output budget line, Aboriginal justice as a whole, there has been a decrease of $2.159 million. It includes a couple of variations, both decreases and increases. So if it's okay with you, I'll just go through what they are. So there's been a $3,11,100,000. All right, I'll say 3.11 million, sorry, decrease due to the expiry of time-limited funding for the law and justice groups. I'll add that most law and justice groups have experienced implementation delays, and the funding already provided will allow the groups to continue to operate into 25-26. The NT-RI funds will also be available to support the law and justice groups. Then there was a $0.418 million decrease due to the expiry of time-limited funding for the Aboriginal Justice Unit. Then there was a $1.3 million increase due to the expansion of the Mediation, Peacemaking and Support to Law and Justice Groups initiative under the Northern Territory Remote Aboriginal Investment, NT-RI, partnership with the Commonwealth. As at the 31st of March 2025, the final budget allocation for NT-RI is being negotiated with the Commonwealth. And there was a $69,000 increase in NTG parameters.
Thank you. So through the chair, Attorney General, might be a question for your Chief Financial Officer. The Northern Territory Government has cut funding in lieu of Commonwealth funding coming in as part of the Northern Territory Remote Aboriginal Investment.
Yeah, I might get the Brett Roach, the Chief Financial Officer. Oh, actually, I might throw to Gemma Lake, the Chief Executive Officer, first to answer that one.
Thank you for the question, Member for 𝙍𝙀𝙀𝙀, and Gemma Lake, Chief Executive. Yes, as you can see from the numbers, there has been a decrease. There has been in this budget a $1.3 million for 25-26 allocated for community courts as well. And the Law and Justice Group's funding, we will be relying on rolling over some existing funding that we have for Law and Justice Groups to continue those going, and also the NT-RI funding. And then that will be supported through evaluation work before we then look to bid for new funding.
Sure. So how many law and justice groups are operational now versus how many is the government intending on bringing forward and commencing this financial year we're about to go into?
I'll just get that information for you. Thank you for the question, Member for 𝙍𝙀𝙀𝙀. There are law and justice groups operating in 5 communities across the Territory: Kintore, Maningrida, Groote Island, Ramingining and Barunga Wagala. A 6th group, the 𝙍𝙬𝙬𝙀𝙀𝙀𝙀 Aboriginal Corporation, received a readiness grant in June 2024. to support establishing a law and justice group at 𝙍𝙀𝙇𝙀𝙍𝙍. That work has not yet progressed, and my understanding is that the AJU is working with 𝙍𝙬𝙬𝙬 to make sure they can work through the next steps.
Okay, so can I confirm how many are you, Attorney General, looking at bringing on additionally to the 5 plus the 𝙍𝙬𝙬𝙬𝙬, which has a readiness grant?
Thank you for the question, Member for 𝙍𝙀𝙬. We will continue with the 5 that are existing and the new 6th one in 𝙍𝙬𝙬𝙬 as that progresses to the next step. We want to focus on how that's going and look at how each of those communities are able to engage with the law and justice groups and look at the data that comes from it.
So there's no, Attorney General, there's no plan for additional law and justice groups this financial year rather than the 5 plus the 6 which are being done. So has any money from grant funding been returned to government?
No, Member for
Okay.
𝙍𝙀𝙬.
So, Attorney General, with your Attorney General hat on, not your tourism hat or the other hats that you wear, how many remote Aboriginal communities have you visited as the Northern Territory's first law officer?
Member for 𝙍𝙀𝙬, coming into government, I have been visiting Alice Springs.
Yeah, that's not remote community.
That's
though.
right. And Catherine, very much looking forward to visiting the rest of the territory. As we know, it's quite expansive. So far, I've had to rely on my department staff to be able to go out there. It's such a big area, it's such a big job. And as you would have heard in my opening statement, there has been a lot of work done in the Attorney General's department and in Attorney General's office, mine, that we've had to implement. So I am looking forward to going out to a lot more places in the Northern Territory in the coming months and years.
So, through the chair,
Apologies, Member for 𝙍𝙀𝙬. You do have the floor if it's a follow-up. Just
Yeah.
noting Member for Mulcahy has a follow-up on
sure,
that question.
it is a follow-up. So, Attorney General, you've been the first law officer of the Northern Territory for 9 months, and you're telling me you have not been to one Aboriginal community. Have you met with any law and justice group in the Northern Territory from a remote Aboriginal community? And then I'm happy the member for Mulcahy.
Thank you for the question, Member for 𝙍𝙀𝙬. So the people that are on the law and justice groups in each of those 5 communities, which we do have, I have not sat down and met with them face to face, but I have via Teams and into my office met with a number of different Aboriginal organisations that are in different areas across the territory. I even met with the board of 𝙍𝙬𝙬𝙬, and I know that's not one of these law and justice groups, but I guess the example of the fact that I'm meeting with as many people as I can at the moment, mostly from from Darwin, because it's, I'm trying to get through a mountain of work and make a lot of change and fixing a lot of what we inherited coming into government. But like I said, I am looking forward to going out to our community courts, and of course we get to meet those law and justice group participants. When I've met with some of the other people across the system, the justice system, such as the chief judge at the local courts, who does do a community court circuit. She's looking forward to having me out there and seeing how that runs. I too am looking forward to seeing how that runs.
It's clear you've said you haven't met with any Aboriginal law and justice group. I'm happy for the member for Mulcahy to ask his follow-up question.
Member for Mulcahy, the floor is yours.
Thank you, Mr. Speaker, and the panel, and Minister, and all the staff. For those, my name is Yingiya Guyula, MLA of the Mulcahy electorate. So, Minister, my question is a follow-up question. Budget paper 3 shows a loss of over $2 million and states this is because of the time limited funding for law and justice groups. These groups were not time limited. They were designed to work with communities, and we want to expand in these areas. I want to see these groups funded across the communities in the Mulka electorate. Ramadgani community have established a group which can continue to work with the NT government. The Yolngu elders who are currently employed as part of the law and justice group are waiting to hear from the government if they are still employed next month. Minister, at the end of this month, what funding will be provided by the government to law and justice groups in the NT? And do Ramadgani elders still have employment in these areas and roles? Thank you.
Thank you for the question, Member for Mulka. The law and justice groups are indeed funded. I mentioned there were 5 that are operating in the territory now, with a 6th looking to establish with some next steps. And they're built into the Sentencing Act. And of course, all of that funding for those ones that are already established and the one new one that's going to be up and running, that commitment of funding continues. In answering part of the other part of the question, I have here some of that funding commitment for those groups. So we had the Groote Island, Groote Archipelago Community Justice Group, and of course that's auspiced by Andaliakwa Royalties Aboriginal Corporation. There was an operational grant in 2023-24 for $560,000. And then another one in 2024-25 for $560,000, totaling $1.12 million. And that particular justice group had 8 sittings to date. They had 23 people sentenced, 41 matters were finalised, and they have 4 approved members. The Maningrida Najara Malia
Namalaya.
Thank you. Cultural Leaders and Justice Group Incorporated. They received a readiness grant in 2022 and 2023 of $60,000. And then in 23-24, they received an operational grant of $156,665, a total of $0.216 million. That group has sat 3 times. They have 8 offenders sentenced, 9 matters were finalised, and they have 6 approved members on that Law and Justice group. In Kintor, in Wallangaru, at their Law and Justice group, auspiced by Yarara College of the Fink River Mission Incorporated, they received a readiness grant in 2023-24 of $60,000. They've then received operational grants in 2023-24 of $560,000, and then 24-25 another $560,000. That's a total of $1.18 million. That group has had 2 sittings to date. They had 2 offenders sentenced. They've had 3 matters finalised, and they have 2 approved members on that Law and Justice group. In Ramadgining, the Binip Liman Marindangining Mala Law and Justice Group, which is auspiced by the Aboriginal Resource and Development Services. They received their readiness grant. There were two, one in 22-23 for $60,000, another in 23-24 for $60,000. Then in 24-25, they received their operational grant of $560,000. So that's a total of 0.68 million. Their first sitting was on the 17th of April 2025. Did that go ahead? I'll just check if that one actually went ahead.
Yes.
Yes, that went ahead. There was one offender listed on that particular sitting, and of course that group has 2 approved members. And the Barunga Law, Culture and Justice Committee, auspiced by the Bagala Aboriginal Corporation, they received a readiness grant in 2022-23 of $49,000. They've received operational grants in 23-24 of $0.5 million, and then again in 24-25, another $0.5 million. So the total there of $1.049 million. Their community court training is scheduled for June, so any day now. Anticipated community court will commence in the second half of 2025.
Thank you. Through the chair, I have 2 more on this output. The Minister.
On the opening statement.
Sorry?
We're still on the opening statement.
Opening statement. Sorry, yeah.
Maybe go back to...
What we can do, Member for Mulca, if you'd like to, if you'd like to ask where your questions are in the outputs, and I'll make sure that they're addressed when we get to that output.
Okay.
So you're free to ask the questions now, and I'll write down the outputs and make sure you get them. So if you'd like to ask your questions.
So ask the 2 questions we're on now at the moment. Yeah.
Brother, they're on the opening statement, so you can ask anything.
Yeah.
So go.
Yeah.
Okay, thank you. Sorry, just getting my mind around things. Through the Minister, continuing with the courts, community courts, I am pleased to see that community courts will continue. We currently have 1 community court in my region that is connected to the Law and Justice group in Ramanganing. But your communities want to see community courts across the region. Is the AG department planning to expand community courts, and is this budgeted for in the 2025 to 2026 budget? How many community courts are operating now, and how many will be seen by the end of the 2025-26 financial year?
Thank you, Member for Mulca. So I'm just getting the information. So there's $1.3 million in the budget for community courts for 25-26. And there's so Member for Mulca, there's some funding that's rolling over, and the department's currently engaging in negotiations with its partners under the Northern Territory Remote Aboriginal Investment Agreement around a proposal to expand that Law and Justice group, the group network, I should say. The community courts, we have a community court in Groote Island and Anaragu. The first sitting date was on the 7th of June 2024, and they've had 8 sittings. There was 23 offenders sentenced across 41 matters. The number of offenders listed for future sentencing was 7. In Maningrida, their first sitting date was the 6th of December 2024. They've had 3 sitting days. They've had 8 offenders sentenced across 9 matters, with no offenders listed for future sentencing. In Kintore, their first sitting date was the 19th of September 2024, with 2 sitting dates. There was 2 offenders sentenced across 3 matters, with no offenders listed for future sentencing. In Ramingining, their first one was on the 17th of April 2025. They've had the 1 sitting date then, with no offenders sentenced across no matters, because the 1 is listed for future sentencing.
The member for Mulka is asking, there's a $1.3 million commitment in the budget for the continuation of community courts. Is that ongoing funding, and is the Law and Justice Group funding ongoing? Because of that 1.3, you've numbered Groote Island, Kintore, a few other locations. Are there new community court locations to be scheduled in the new financial year, is what the member for Mulka is asking.
Thank you, Member for 𝙍𝙀𝙇𝙀𝙎𝙏. It is anticipated that a community court will commence at Barunga Wagala in the second half of 2025. But noting that these initiatives are currently subject to evaluations, the long-term funding decisions in relation to them will be made, once we've been able to consider the outcomes and the findings of how they've been going. I mean, as you can see from the dates of those first sittings, they're fairly new, and they've had sort of small numbers of court dates out there. We're very interested to see how they go, and ensure that they are, delivering on what we want them to deliver. And of course, if they're successful, then we'll look at expanding them, or how we can improve that going forward.
Can I ask a follow-up, Chair?
Member for Johnston.
Thank you. And in relation to community courts, I noticed that one of the actions under the implementation plan was to provide community courts with improved sentencing options relevant to their location. So what improvements have been made to the range and availability of culturally appropriate sentencing options for community courts where they're operating?
Need some lollies now.
Thank you for the question, Member for Johnston. So the community courts in and of itself is a practice which is new, and that has now been implemented and is showing a number of sitting days there. The sentencing options, as an example, the alternatives to custodies, we have 2 of those across the territory so far, and that is a different option that wasn't available before. Well,
it was. The previous government introduced that.
No, I'll correct the record there. I wasn't saying that our government introduced alternatives to custody. That was of the previous government. I guess we did, increase the beds in Groote Island, so there's 32 there now. But when I say they weren't there before they were there, there was nothing there. It was only one option in terms of incarceration. So that's...
I'm interested in any improvements.
So, Member for Johnston, thank you for the question. The dates in which these community courts have started to be operationalised, it's fairly new. It's only a few, one of them is 6 months in, and I think it's a bit too early to evaluate exactly how they are improving or not. And that's the data that we're really looking forward to seeing how they're going, and then that includes in the alternatives to custody. We know that there's people that do go into those facilities, and obviously they do come out as well, and we want to see rates of reoffending reduce, and all of that data, it really is just too early to be evaluated. We all want to see improvements in terms of people reoffending less and being able to live a life beyond crime, and so I look forward to seeing what that looks like into the future.
Sorry, member for Johnston, is your mic on? Yeah.
So just to clarify, at this point, there's no new programs, developments, alternatives, apart from the ones that had been put in place that are
That's
continuing.
correct, Member for Justice, because we want to see how these ones are working, both the community courts, the law and justice groups, the alternatives to custody. It was a new concept for the Northern Territory a number of years ago. They've just recently been implemented to be able to do those court hearings, and oh yeah, thank you, and the sentencing options to those alternatives to custody. So we, like I said, we're really looking forward to the evaluation of those, because once we have that information, we can determine if and how they are improved, expanded or not, or which area we focus on. We're really keen as a government to see what's working and what's not, and making adjustments and changes along the way. And we'll continue to do that in this space as well.
Thank you. And I've got, which I'll ask at the output questions about evaluation, but just around this specific one, is there a timeline for that evaluation?
Member for Johnston, the evaluation timeline, we're looking to see what the data and the evaluation is to date up until the November 2025, and we'll be able to have a look at all of that and go from there.
Okay. Through the chair, Attorney General, how many people across the Northern Territory have been released on bail since your new bail laws commenced on the 6th of January?
Thank you for the question, Member for 𝙍𝙬𝙍𝙎. Because, as you know, the dates, the things fluctuate quite a bit, but I do have points in time of total people on bail. And I can report that on the 31st of May 2025, the total on bail was 1,962 adults and 210 young people.
So, but Attorney General, I'm after data that I know you can get from the agency and the courts, because when people are sentenced, it's recorded. So, how many people since the 6th of January 2025 have been awarded bail?
Just finding that data for you, Member for 𝙍𝙬𝙍𝙎. Thank you, Member for 𝙍𝙬𝙍𝙎. So the data I have at the table on me right now is the data I said about the total people on bail. What I don't have right here, and I'm happy to take it on notice, is the number that were. I just need you to restate exactly what that is, so we can find it out.
Member for 𝙍𝙬𝙍𝙎, please restate the question for the record.
Thank you. Attorney General, how many people across the Northern Territory have been released on bail since the CLP government's bail laws commenced on the 6th of January 2025? And how many of these were or are facing a violent offence?
Attorney General, do you accept the question?
Yes.
The question asked by the member for 𝙍𝙬 of the Attorney General has been allocated the number 5.3. Member for 𝙍𝙬.
Thank you. To the Attorney General, very happy as well. I understand you'll probably want to take this one on notice as well. How many between your first tranche of bail laws and the new bail laws passed on the 30th of April 2025?
Of the same data, of
Yes.
those that have been released on bail?
Yes.
And the same data with the serious offence?
Yes.
Yeah. I'll just check if we've got that. Yeah, we might need to take that one on notice as well.
Right,
Member.
I'll
Member
restate.
for 𝙍𝙬, please restate the question for the record.
Thank you, Mr. Chair. Very kind there. How many between your first tranche of bail laws and the new bail laws passed on the 30th of April 2025? How many of these were or are facing violent offence charges?
Attorney General, do you accept the question?
Yes.
Thank you.
The question asked by the member for 𝙍𝙬 of the Attorney General has been allocated the number 5.4. Member for 𝙍𝙬.
Thank you. Attorney General, did you see the advice provided by the Solicitor General to the Chief Minister about whether or not she should name the former Police Commissioner Michael Murphy as the senior public servant who was subject of ICAC's Operation Apollo?
No.
Thank you.
Can I just ask a follow-up to
Follow-on
your
question.
previous
Member for Johnson.
one? Once you finish this line, Chancellor.
Okay, I'll hand back to the member for 𝙍𝙬.
Okay. So just to be clear, Attorney General, you did not see any advice at all from the Solicitor General in relation to the former Police Commissioner around Operation Apollo?
No.
No advice at all? Thank you. Has the Solicitor General been asked by the government to prepare any advice concerning the finalisation of Andrew Kirkman's employment?
That would be a question for the OCP, Mr. Chair, because I don't have any information about that department and that public servant.
Thank you, Attorney General. Member for 𝙍𝙬.
Thank you. I'm happy to kick that down the can because OCP is on today, so I'll ask them there. Has the Solicitor General been asked by the government to prepare any advice concerning the finalisation of any other former CEO's employment in the reporting period?
I don't have any information about that one either, Member for 𝙍𝙬.
Attorney General, according to the communique from the last Standing Council of Attorneys General, also referred to as SCAG, the following matters were discussed: a national hate crime and incidents database, responses to anti-Semitism, closing the gap justice agreement targets, responses to gender-based violence, responses to the abuse of older people, vicarious liability and institutional accountability for child sex abuse and the protection of children and young people in the workplace. These are all critical matters of importance. Why didn't you bother to attend?
Thank you for the question, Member for 𝙍𝙬. The SCAG meetings are held usually interstate, and there's a number of them each year. Upon coming to government and being appointed as the Attorney General, there has been a lot of things that I've had to get across and fix and look at problem solving right across the portfolio. And so when opportunities arise, when there is those ministerial council meetings, we need to look at all of the factors of the work that we're doing, of the agenda, and I guess who's been involved to date of some of those items. And so in that particular case, I chose to use a delegate, being the Chief Executive Officer. And of course, that information from those meetings comes back to me for us to look at. And it's common practice. It's not unusual that happens.
So through the Chair, the Standing Council of Attorneys General is the premier body for attorneys from around the country to come together and talk about important law reform. How many SCAG meetings have you actually attended, Attorney General?
So, Member for Guyula, there has been 2 SCAG meetings since I became the Attorney General, both of which fell during times where I chose very deliberately to send the Chief Executive Officer to go in my place.
So by
And
your
that
own admission,
decision
you
was-
deliberately chose to
Member
not
for
attend.
Guyula, please, we'll let the Attorney General finish and then you will have the floor. Attorney General.
Yes, I choose whether I go or not, and in this case,
You chose
there were
not to go.
2, and the by looking at all of the agenda items and the things that I had going on in the territory, in literally a crime crisis, so many laws that we were changing, trying to fix the mess that we inherited as a new government. We absolutely had to get on with the job prioritising Territorians in the space of reducing crime, and that a lot of that stuff fits under my portfolios. And we'll get to tourism later, but of course I'm also the tourism minister, and that forms a huge part of rebuilding our economy. And so,
Point of
my
order.
Chief Executive
Through
Officer,
the chair.
Attorney General, Member for Guyula.
Very particular question. How many SCAG meetings have you attended? Have you attended any virtually?
Thank you for the question, Member for Guyula. There have been 2 meetings interstate of those SCAG meetings, both of which I delegated my Chief Executive Officer to attend. I think maybe one of those was attended by Ms Lake in person and the other on video, and both in person, I might add, and all of the conversations that were had were relayed to me in briefings and meetings that I've had with the CE since that time.
Thank you, Attorney General. But Attorney General, of course, you must clearly acknowledge and identify that the Chief Executive Officer, a very well-respected person in the Northern Territory, cannot participate at the level of an Attorney General around a table with Attorney Generals. They have to sit at the back of the room and they can't participate in that dialogue. You're saying you're in the Territory. Well, I think that justice target agreements, anti-Semitism, national hate crimes, gender-based violence are all important issues for the Territory. Will you be attending the next SCAG meeting?
Member for Guyula, thank you for the question. And as SCAG meetings arise, I look at the agenda, I look at what's going on in the Northern Territory, and I will make an informed decision at that time. I think you all know that my priority is with Territorians. My priority is with reducing crime, rebuilding our economy and restoring our lifestyle. Every decision I make has that lens of it, and if and when another SCAG meeting comes up, I will make that decision based on those facts.
So, Attorney General, one of the issues that comes up at SCAG, or the Standing Council of Attorneys General, is obviously around the age of criminal responsibility. So, Attorney General, can you provide this committee with your understanding of 𝙍𝙬𝙼𝙍𝙍𝙍?
Thank you for the question, Member for Guyula. Of course, 𝙍𝙬𝙼𝙍𝙍 is part of our legal system. It's there for a reason.
I'm asking you for the definition. What is it?
Member for Guyula, please, I'm just going to remind everyone of the process of the committee. Please, if you have an interjection, alert me and tell me what your interjection is. This will be the last question. The member for Guyula has the floor.
Thank you, Chair, and thank you, Member for Guyula.
Attorney General, I don't want you reading off your phone. I want you to tell me what 𝙍𝙬𝙼𝙍𝙍 is.
Okay. Again, member for Guyula, please, through me, just say, Mr. Chair, I feel my question is not being answered, and I will address it with the Minister.
Mr. Chair, I feel my question's not been answered. Attorney General, can you please tell the committee what 𝙍𝙬𝙼𝙍𝙍 is?
Thank you, Mr. Chair, and thank you, Member for Guyula. Mr. Chair, I know he's being really cute with me, and I'm okay with that because it's just the way that he operates.
Well, you're
But,
the first
okay,
law
Mr.
officer.
Chair,
Surely you can answer a
Member for
question about
Guyula,
laws you reform.
Member for Guyula, Attorney General. Thank you. The time now is 10:53. We'll take a 10-minute break. We will reconvene at 11:00.
Well, hopefully you can get a briefing about it while you're on your break.
Time now is 11:04. We'll reconvene.
Thank you. Attorney General, last week the Commissioner for Public Employment released new tools for the public service to strengthen transparency, accountability and best practice in the Northern Territory Public Service recruitment and selection processes. Will these new tools be applied to ensure a transparent, accountable and best practice approach to recruitment in relation to the Director of Public Prosecutions, or will you interfere in that process as you did with the Director of Legal Aid?
Thank you for the question, Member for 𝙍𝙀𝙇𝙀𝙎. The DPP, I'll address that part of the question first. Obviously, that is a statutory organisation. The DPP is appointed by the Administrator under Section 4 of the Director of Public Prosecutions Act. There is a process that we're looking to undertake with that. Convention is for the appointment of the DPP that follows a process, the same process as the appointment of judges in the Judicial Appointments Protocol. It involves an expression of interest process with an advisory panel comprised of the CEO of the department, the Solicitor General, and a retired Supreme Court judge who make recommendations to the Minister, who then advises the Administrator through the Executive Council. In this case, under the Act, the process used will ultimately be approved by me as the Minister prior to the process proceeding. Just on the Director of Public Prosecutions specifically, that work hasn't commenced yet because we do need to wait for the formal resignation to be accepted by the Administrator before we can start that process. And referring to just the comment that you made about the Legal Aid Director and my appointment for that role, I'll put on the record that appointment is made by me as the Minister under Section 18 of the Legal Aid Act. The chair of the Legal Aid Commission at that time ran a public recruitment process with a panel, and they made recommendations to me as the Minister. The particular director that I did appoint was shortlisted on that process in that panel, and of course me as Minister made the final decision to appoint that director.
Thank you. And last question before outputs for me, Mr Chair. Attorney General, just wanted to confirm some matters in relation to the waterfront. Are you aware of any fraudulent behaviour occurring at the waterfront at all?
Mr Chair, it's not specifically this portfolio. I am more than happy to answer the question, but I do think that given it's about not only an output but like a government organised corporate entity who will be appearing at estimates later today, I think it would be a fair process for them to also be here to answer further questions about that. I guess your call, Chair, but I think it's important that they have a right to...
Well, it's not the Chair's call, it's your call if you want to answer it or not, through the Chair.
Well, so Attorney General, if you are free to defer it to the specific output, and the member for 𝙍𝙀𝙇𝙀𝙎 is free to put it on notice if he so wishes as well. Attorney General.
So thank you, Chair. Thank you, Member for 𝙍𝙀𝙀𝙀. Firstly, I do not have any information about fraud and the allegations at the Darwin waterfront, and you will all well remember, and for the record and the transcript, that from the outset of online claims that I was transparent with Territorians. I first requested a briefing to look into those online claims when they first emerged, and that briefing raised no questions for me and showed no evidence of wrongdoing. And of course, since that time, we had a referral into the Parliament from the Leader of the Opposition, who put forward a referral to the Public Accounts Committee, of which we have Labor and an independent on, and that process ran its course. They questioned the officials at the Darwin waterfront, and they concluded unanimously that there was no case to answer for and that those online claims were indeed baseless. So given that the process I went through with the briefing found no wrongdoings, followed up with a process through a Public Accounts Committee with the Labor members and independent on that committee, still found for no, there's basically baseless claims to those online allegations. There is nothing to answer for. Like I said, those officials from the Darwin waterfront will be appearing before estimates later today, and I welcome any further questions.
Thank you. Through the Chair, happy to ask the Darwin Waterfront Corporation further questions when they're here. I do acknowledge that you have stated that you're not aware of any fraudulent behaviour. I just, one final question on this matter. Attorney General, you stated that you had read the report and that you had made the assumption. I'm wanting to confirm, did you in fact read the report and make a decision based on fact, or have you assumed?
Member for 𝙍𝙬𝙍𝙎, when I received the briefing, I read that. I found that there was no wrongdoings in that evidence that I was presented, and I made those. I made the determination that there was no wrongdoings and that nothing further was needed to be done.
So, Attorney General, just picking up on your language there, you've said you've made the determination now, not the assumption. Do you acknowledge that that was the wrong use of words at the time then?
Member for 𝙍𝙬𝙍𝙎, thank you for the question. I believe that I have answered my question. I've been in front of media quite a few times and in Parliament in question time
where you've said
answering
you've
these questions. The briefing that I sought, I read. I made a determination that there was no evidence there of any wrongdoing.
Not an assumption.
And
Member
so
for
I...
Sorry, Attorney General. There's been a number of interjections that'll be the last informal warning. Attorney General.
Thank you, Mr Chair. I think I've answered the question.
Member for 𝙍𝙬𝙍𝙎.
Thank you, Mr Chair. I'm very happy to move on to outputs if no other members have questions about the opening statement.
Member for Johnston.
Just a clarifying question. In relation to the Director of Legal Aid, did you say that the person who was appointed was recommended through the shortlisting process?
Thank you for the question, Member for Johnston. So the panel that was doing a recruitment process provided me 9 names, I believe, nine names of people who were shortlisted out of that recruitment advertisement, and they'd been through that process. I then chose the person, one of the 9 that were on that list.
So just to clarify, the person who's been appointed was recommended by that panel?
So the panel provided me with 9 names on a shortlist, and I, as the Minister, had the final say in terms of who I appoint based on the Act, and I determined one of those people that were shortlisted be appointed.
Thank you. I just want to be totally clear. So the person who was appointed was on a list of 9 names, but not someone who was recommended by the panel, because your role is to make the decision yourself. Is that correct?
My role is to make the decision of who I would like leading Legal Aid NT into the future as the Director. I was looking for very specific skill sets and character to be able to make reform within the organisation. Obviously, we are making reform right across government. There are lots of challenges that we have, and I chose that person based on their change management opportunity to be able to make those changes, and of course the skills. The particular successful candidate being Catherine Vomard has a lot of deep experience, not only in the Northern Territory but in other parts of Australia, who have worked with legal aid before, with NARJA, at a private firm as well. There's a big, huge range of experience there that I think that she will bring to the Northern Territory and the Legal Aid Commission. Thank you.
Through the chair. So thank you for providing your rationale. I think we're all quite familiar with the experience of Ms. Vomard. But just to be, just very clear question, there was 9 names provided to you. The name that was provided to you was not someone who was recommended by the selection committee. You made a decision based on what you believed was appropriate for that role, correct?
The shortlist did come to me with the 9 names. I looked at all of the 9 names and I made a determination based on what I was looking for in that commission.
Through the chair, was Ms. Vomard recommended by the selection panel?
I should make it really clear, thank you, Member for Johnston, that under the Act, that the Minister appoints the Legal Aid Director. It says there quite clearly they may consult with the Chair of the Legal Aid Commission, which I did do, about the appointment. And ultimately, though, it doesn't matter whether a panel was there or not. The Minister still makes the ultimate decision, and I did make that ultimate decision.
Through the chair, I understand, Attorney General, but the answer is no, that was not someone who was recommended by the selection panel, understanding that you've said you don't need to pay attention to what they say. Is that right? That was not someone who was recommended?
The person that was appointed was shortlisted. So out of all of the applications that were received by that panel, 9 were put forward to me, and I chose one of the 9.
Through the chair, the person you appointed, though, was not the preferred candidate by the panel, not by you, but by the panel.
Thank you for the question, Member for 𝙍𝙬𝙍. I think I've been really clear about this. There was a recruitment process with a panel. There was 9 names given to me on a shortlist. I looked at all of those 9 names and their applications, and I made a decision as the Minister that I would appoint one of those 9 people.
And through the chair, do you acknowledge that there have been a series of resignations from within Northern Territory Legal Aid Service because of this appointment, and that there's been resignations of significant, highly distinguished and qualified legal practitioners from the board because of your appointment?
Thank you for the question, Member for 𝙍𝙬𝙍. It is true there has been resignations from the board of commissioners at the Legal Aid, including the chair. And those board members have been at Legal Aid for a very long time, and it is a matter entirely for them as to whether they would like to stay on or not. Of course, the experience that they do have will be missed from the board, but at the same time, Member for 𝙍𝙬𝙍, we were elected on a platform of change, and we've been really clear and we've shown through our actions that we will be changing so many things about the Northern Territory, and in this case, that includes legal aid. And so if board members have chosen to resign, I should make it very clear that none of them have been asked to leave. They have chosen to resign. It is a question for them as to their why. I'm not going to speak for them, but I welcome the change of the board, because we will go out to an expression of interest now and see who is out there that may like to come on that board and help the Legal Aid Commission to be able to reform themselves so they can provide quality services for Territorians who need legal representation. They acknowledge that there's work to be done in that space, and that's the outcomes I'm looking forward to seeing with the change in leadership and the reform that we're undertaking.
Thank you, Attorney General. We do have, so in order of that they've notified me, of questions on opening statement, we'll have member for Karama, followed by a member for Nightcliff, and then I'll put it to the floor if there's any others before we move on. Then member for Nightcliff, you have the floor.
Thank you very much. Just on the appointment, was Deputy Chief Minister Maley, did you confer with him about the appointment?
Thank you for the question, member for Nightcliff. Can you just clarify what you mean confer with?
Talk, discuss, consult.
Thank you for the question. There was, I can't speak about exactly in terms of the cabinet confidentiality, but with appointments under Acts, the recommendations need to go to cabinet to be signed off. So I can't talk about what happens in those meetings as such, but what I can say is that the appointment of Ms. Vermaad, who is the right person in my opinion, I recruited her in terms of saw her on the shortlist, saw the skills and the attributes that I needed, sorry, that's the wrong word, the character that I needed for change reform, and I appointed her, and I'm really looking forward to that change going forward.
There's been some confusion around this. Was the Deputy Chief Minister's brother a work referee for Ms. Vermaad?
No, he wasn't.
Okay. But it has, I think it's public knowledge that they used to work together. Was that conflict of interest? Did you consider that a conflict of interest?
Thank you for the question, member for Nightcliff. So as far as my appointment, decision to appoint her, I took into account her whole work history and where she's worked. The Maley's law firm in the Territory is quite significant. There's a lot of people who've worked there in the past. I certainly see that as a quality, given it's a private practice alongside her skills and experience with in legal aid and NAJA as well. Like, it's a good complement to have that variety. I did not see that as a conflict. There was no recommendations from the Deputy Chief Minister or his brother to me about that specifically. It was more along the lines of, I saw the resume, I could see where she'd worked before. I took that into account based on her entire application.
And so when you just spoke before about through the chair, around the confidential discussions in Cabinet, I think around the application, did the Deputy Chief Minister recuse himself from those under conflict of interest?
Yeah, it's been a long-standing code of conduct under the Ministerial Code of Conduct law rule with Cabinet that we don't discuss what happens in Cabinet outside of Cabinet. Those records do become available after 30 years.
Member for 𝙍𝙀𝙇𝙀𝙎, sorry, Attorney General, member for 𝙍𝙀𝙍. That will be the very last interjection before
Apologies,
a
Mr.
warning.
Chair. Sorry.
Member for Nightcliff.
Oh, that's okay. I think you were answering it. Sorry, but I just want to confirm, are you able to tell us, and I understand they're confidential, but are you able to tell us whether that conflict of interest was managed?
I can't actually speak about anything that happened in Cabinet, but those will be released in 30 years' time.
We'll all be dead by then.
Hopefully not, member for 𝙍𝙀𝙍. Member for Karama.
Thank you, Chair. Attorney General, I'll just go back to your opening statement. You obviously made reference to the stronger legislation this government's brought in. Obviously, from my electorate, and I'm sure other electorates, community safety is a real key issue, and people are looking for tougher consequences. And I'm sure it's not just my electorate but shared across. But when we came to government, we made a commitment that in the first weeks of Parliament we would introduce certain legislation under your portfolio. Obviously, they revolved around stop the revolving door of bail, all in our plan, as I always remind people. Make breach of bail an offence, new minimum mandatory sentencing for assaulting frontline workers, etc. Introduce ram raid legislation, and also posting and boasting legislation, plus others which strengthen police powers and so on. What I'd like to know, Attorney General, is having introduced those, have you got any sense or any evidence that it's starting to work in terms of people who used to be released on bail and no longer being released and so on, that's making the community feel safer? Or if you can give me any evidence, I know it's early days, but if you can sort of give me some evidence that the impact of these laws are working in the right direction to improve community safety. Thank you.
Thank you, Member for Karama, for the question. You're right. We've made a number of changes since coming into government, and it's a really good question to ask in terms of what has been the impact or the outcome of the changes that we have made. You already mentioned that we came to government, and in the first 6 weeks, I think it was 8 weeks, the first sittings, we passed a suite of crime reducing pieces of legislation, including Declan's Law and the others that you mentioned. I can share with the committee some of the outcomes of how they are working in practice, but also the things that they're where the reductions have occurred in our community. Sorry, I just wanted to find the actual stats from my statistician. Thank you. So since there's some data here that's a point in time, and I think I might use the 31st of March 2025 number because that is this reporting period, and I think it's the numbers speak for themselves. Like, I know that the Deputy Chief Minister always talks about the 550 extra people behind bars now due to our laws. And I think that's a really important measure. But I also think that it's not what I want. I'm trying to read these statistics that I've been given. Yeah. You mentioned the remand, and that's a good measure we could try. So in March 2024, there were 903 people on remand. But in March 2025, there are now 1,323. So that's quite a significant amount of people who are not getting bail right now. As you know, we came back to Parliament urgently in April to strengthen those bail laws even further because we needed to send a really clear message that if you're out there committing serious crimes, then you don't get to be out in the community because you can't do that and keep the community safe. So, of course, that has impacted in, people, there's just no bail anymore. They're not getting bail. They're not able to go out and commit more crimes.
Well, that's not true because bail still exists.
Having
sorry, Chairman General, Member for 𝙍𝙬𝙍𝙎, I hate doing it to you.
That's all right, it's my first one.
That is your official warning. Attorney General.
Thank you. And I think the message that we've given to the community is that Territorians and victims come first now, not only with this budget, but just with our whole approach to governing. We took to the election that we would reduce crime, and those new laws are in play. People are being apprehended by our police, and we do have more police out on the beat now, but once they are before the courts, then they are being dealt with the right, strongest laws that are that we can possibly have to keep Territorians safe. I'm just going to find a couple of extra stats for you, Member for Karama, on.
Through the chair, Mr. Chair, may I so kindly ask you that once the attorney's asked, I've got a few follow-up questions from the member for Karama.
Of course.
And I've got a question as well.
Oh, everyone's got a question.
Okay, the order of follow-up questions, once the Attorney-General answers this, will go member for 𝙍𝙀𝙍, member for Blaine, member for Johnston, in the order that I was notified.
It's got to be a follow-up.
That's where we after the follow-up.
Is yours on this one?
No.
Okay. We'll amend that. It will go member for Johnston, then member for Blaine.
Thank you. Thank you, Chair. So I'll continue my answer about the impact that these new law changes are having. So we always talk about how the crime statistics are only one measure of how a community is feeling when it comes to being able to live their life as they want to without fearing going down to the shops and filling up your car at night and taking, you're sending your kids on a bus to school. Like, it's more than just the crime stats, it's how they feel when they're doing that. And we certainly know that over previous years that those decisions that people were making were literally impacting their lives. And so now, whilst it's not, we're not there yet in terms of people feeling safe, we certainly are seeing some signs and some indicators that the numbers of crime are reducing. So across the Territory, and this is up to the March 2025 quarter, we've seen property crime down 12%, and break-ins have dropped sharply by 43%. In some regions, we're seeing that by over 54%. I mean, that's huge. So to be able to have a decrease in property crime, that could be where you live and your kids are sleeping and people breaking in, or when you're not home and they're coming through and you're having to arrive home to see a break-in. I mean, that's just devastating to go through as a victim. We have seen, in Alice Springs in particular, house break-ins are down 53% and commercial break-ins are down 28%. We saw over the last number of years Alice Springs going through a terrible time. I guess I want to acknowledge the fact that we still have a lot of work to do in relation to assaults and domestic violence. That still continues, but we really have only been in government for 10 months now, and I think we've demonstrated through our actions that we're serious about reducing crime, and we'll continue that work so that Territorians can enjoy their lives here.
Thank you. And I do have a follow-up question myself, Chair. So, Attorney General, you referenced that the corrections, we've got more people behind bars, 500, 600. You also referenced that the number of people on remand has increased. This probably puts more pressure on our courts, one would expect. So I'd like to know what has been done to reduce court delays, improve prosecution capacity, and deliver faster outcomes for victims.
Thank you for the question, Member for Karama. And I did talk about this in my opening statement, which I guess is why you're asking the follow-on question. So with the courts in particular, we recognise that there was a massive backlog. They were clogged. They were facing increased demand pressures. A number of factors were involved with that, and we inherited this, which was, it didn't happen overnight. Like these demand pressures were growing over a lot of time, and what we know is that when you invest in police, you also have to invest in courts and corrections, which is something that we've started to work towards now. We've got this biggest law and order budget that we've had in history of the $1.5 billion invested. We put an additional local court judge to be able to deal with the number of cases that are coming through, given our police are now really proactively out there doing an amazing job. They were given a directive from the Chief Minister to, be out there, be seen, be proactive, and they're doing that, which means that now the courts are seeing higher numbers come through. So we've got the extra judge and the support staff are going to go with that as part of this budget. We topped up legal aid, which I've talked about quite a bit here today, because they needed the extra funding to be able to see more of their clients because they need to be represented. If they're not represented in courts, it slows down the justice system, which of course is longer then for victims of crime to go through the process. I mean, they're trying to, recover from a crime, let alone having to wait for so long because of a legal service which is unfunded and not being able to deliver. Then on the other side of the fence, under prosecutions, we found that there was the office had prosecutors that were employed by the government that were on casual contracts, like rolling 12-month casual contracts, which gave them no certainty whether they would be there from one year to the next. So we have made all those prosecutors permanent now. We've also increased the number of prosecutors by 4 and some staff. That also will help the court's backlogs. And I talked earlier about that targeted intervention group early resolution where they're going through a lot of cases, and if they can determine that something can have an early plea of guilty or kind of triage where it's at, grab all that evidence. There was a pilot program going on in there with the police being involved to provide the evidence so they can make those decisions early, and that so far has been quite successful. I think there's been 290 remand cases reviewed, 240 of them have now been finalised. I mean, that's a huge number that was sitting in the system for such a long time. And of course, in this case, 104 of them were guilty pleas, which means that those people now can have their sentence. They can start their sentence if there is one, and if there's rehabilitation or programs, whatever it is they have to do, they can now get on with that. But also, that means that the victim also has that point in time where there's been that justice, and I think that's really important and something that had been forgotten about for a very long time. Thank you, Member for Karama.
Thank you, Attorney General. So we'll go to the follow-up questions in order, being Member for 𝙍𝙬, Member for Johnston, and then we'll go to Member for Blaine. I do note we are still on opening statement and there's a lot of outputs, but it's completely up to the committee.
Thank you. Attorney General, you spoke about remand numbers. Could you confirm that the additional 500 presentations before Northern Territory Correctional Services had an outstanding warrant for their arrest, rather than these are not all new offences?
Thank you for the question, Member for 𝙍𝙬. I believe that would be a question for either police in terms of the warrants and the numbers about which part of the correction system that extra 500 and 550 came from would be for corrections.
Sure. Can you confirm, though, Attorney General, that bail is still being granted?
Thank you for the question, Member for 𝙍𝙬. Bail is part of our system, our legal system, our justice system, and of course the courts and the decision makers will determine those, both police and judges.
So you can acknowledge that someone who commits a violent offence may still be getting bail?
Thank you for the clarification, Member for 𝙍𝙬. The new laws put in place that the decision maker must have a high degree of confidence that that person is not going to go out and reoffend or endanger the community, and that's after Declan's law has been applied with that presumption against bail, and so the extra tests that they have to determine whether they have bail or not means that there are less people getting bail.
But people can still be, through the chair, people can still get bail for committing a serious violent offence in the Northern Territory under the laws.
Thank you for the clarification, Member for 𝙍𝙬. Like I said, the bail laws are now in place with the extra tests being applied. They are the strongest in the nation, absolutely. There is still an element of bail that must be applied because that is our justice system, and the decision maker being either the judge or
through the
police.
chair, I know it's not you, but the laws that you set still allow the potential for the judiciary to consider a violent offender could still be awarded bail.
Of course, a decision maker, being police or the judge, will be the one that assesses all of those things. So ultimately, it is their decision based on the strong laws that we have put in place. They were laws that weren't there before. So we have strengthened those because we make no apologies for the fact that we want Territorians to feel safe and that we have a lot of work to do. We want to reduce crime. We know that by having these strong bail laws, that and those offenders who in some cases are repeat offenders or they are serious and violent offenders,
So
we don't
what I'm
want
hearing
them back
is,
out on the street.
yes, there's the potential
So
for that to
will-
happen. It's not your decision, but yes, there's the potential for that to happen, is what you're saying.
The judge and the police have the final
Same.
decision, but they have to apply those tests, and those tests mean that there are absolutely less people getting bail under the new strong laws.
So the member for Karama was talking about stats, and we heard earlier this week the Chief Minister saying you can't cherry pick stats. So I guess, Attorney General, through you to the department, is the department confident around the statistical validity issues with Serpro have been resolved? And from what month is it reasonable to start looking at an analysis of compatible data?
Thank you, Member for 𝙍𝙀𝙇𝙬𝙎. You will know that we have some really great expertise coming forward who sit in our statistics area. Carolyn White, the Director, Criminal Justice Research Evaluation and Statistics Unit of the Attorney General's Department. She has been doing these statistics for a long time now, and I might actually throw to her to explain how that all works.
Thank you, Minister. Thank you, Member for 𝙍𝙀𝙬𝙬. So in terms of the crime statistics, that data is continuing, and we are in the process of starting to put out comparisons starting from January of 2024 through March of 2020. January 2024 through March 2024, compared with the same period in 2025.
Okay. So, through the attorney, if I may, is the statistical unit confident around the validity of the Serpro data? No, it's not.
Okay. Committee. Member for Blaine, if you have a point of order, please turn the microphone and direct the point of order to me. I will then decide without input.
They're making themselves look stupid.
Member for Blaine.
Mr. Chair, I believe according to standing orders, it's a hypothetical question. Can you?
Member for 𝙍𝙀𝙬𝙬𝙬, could you restate the question for me?
Absolutely. However, I don't think asking a department if they're confident or not is out of order. So through the chair to the Attorney General, is the department working through, and can the department confirm that they are happy with the satisfactory or the conduct of Serpro and its validity?
I'll give that to
It's
the
not a
Attorney
hypothetical.
Yeah, through myself, I answered the questions and I moved to the department if needed. It's not a hypothetical, but it is asking for an opinion, which I'm actually happy for Ms. White to answer the question because she has a lot of detailed experience in the statistics and the changeover between the old system, Promise, and the new system, Serpro. So, Ms. White, happy for you to answer the question.
I will, and just as a matter of process, for anyone who's not the Attorney General, when you speak, if you could just please say your name for the Hansard. Thank you.
Thank you, Minister. Carolyn White, Director of Research and Statistics. My team works quite closely with the police in terms of looking at the data, understanding the data from Serpro, how it's collected, how it's recorded, and certainly I would say that the data quality is improving. There are always changes that happen in the very first month of a new process, but certainly as we learn more about the work processes that happen with Serpro, we are better able to extract the data, and certainly we're working very closely with police on making sure that both agencies have the same understanding of what that data is and how it's best to use.
Thank you. So through the chair, Attorney, I'm just wanting to understand, have the issues been ironed out with SERPRO to start giving us accurate, comparable data year on year?
Carolyn, Ms White.
Okay. Thank you, Member for 𝙍𝙀𝙇𝙀𝙎. Minister, the change in the data from SERPRO appears to be permanent. So there are different business processes that happen with the entry of data into SERPRO. So no, we're not going to be, from what we can tell, in a situation where we can compare data that we're getting now through SERPRO directly with data that was previously collected through PROMIS. That means that year on year, currently we are, if you like, quarter on quarter. As time goes past, then we will be getting into year-on-year comparisons. We don't, at this stage, believe that we will be comparing post-SERPRO data with pre-SERPRO data simply because it is a different program.
So through the chair, is there a figure that is a percentage of consideration? I note that there was previously an estimated 15% variation in the numbers. Is that still the same, Attorney?
I'm happy for Ms White to answer that question.
Thank you, Minister. Thank you, Member for 𝙍𝙀𝙍. We don't have a specific figure in terms of that variability. Certainly the change that we saw varies with the type of offence, with the location of the offence, and there are a number of changes that have happened. What we are seeing is certainly the links between some of the SERPRO data and some of the data that we're getting elsewhere in the system linking up much better because we have an electronic link now. And so there isn't a specific figure of change, but what we are seeing is that with the post-SERPRO data, that's where we'll draw the line and continue to go from that point.
Okay, thank you. And Attorney, just one final question. The Child Death Review Committee hasn't met in 6 months because they can't make a quorum, yet there's been 10 child deaths not reviewed as a result. Do you find that a significant issue, and what are you going to do to rectify that?
Thank you for the question, Member for 𝙍𝙀𝙍. The Child Death Committee, you're right, they have not met. We are looking at a number of governance structures that sit with boards and committees across my portfolio. I've had the department go through each of them to give me advice on how they work, what they do, how many times they meet. We're now looking at seeing which boards and committees we slightly change or we might improve in some way. I think with the Child Deaths Committee, the coroner also does do reports into deaths, including child deaths.
So through the chair, the question I'm asking is, has there been a directive from yourself or the Chief Executive to other responsible agencies to mandate that there is the relevant staff there so there is a quorum? Because there have been 10 child deaths as a result that have not been reviewed.
Thank you for the question, Member for 𝙍𝙀𝙍. I haven't given any directive on this particular board. What I have asked is for it to be looked at along all the other boards and committees. I have a number of them under my Attorney General portfolio which do a variety of things, and like we have done with many areas of governing since coming into government in August, is not accepting the status quo.
You've just said in your response that there are other boards on hold. What are those boards?
I didn't say that. I said that we were looking at all of the boards and committees across my portfolio and that there are quite a few of them. And what we're looking at is what their role is, what they look at, what the outcomes are, and how they support government to be able to implement different reform.
So is it your understanding through the chair that those committees and boards have all still been operating for the 10 months, or have they been like the Child Death Review Committee and not been meeting?
Thank you, Member for 𝙍𝙀𝙍, for the clarification. So in that particular board, they don't have a quorum right now, so they've not met recently, and that process is being looked at as a whole in terms of alongside of the other boards and committees, what they do for government, how many times they meet, what it costs, I guess, how the outcomes of those meetings inform government.
Sure. So, Attorney,
reform.
Through the chair, would you be willing to take on notice to undertake work to advise this committee under your portfolio of Attorney General and Justice, what committees have been in operation, how many times they've met, how many times there hasn't been a quorum?
Attorney General, do you wish to take that on notice?
I can actually answer that now, I believe. Let me attempt to, Mr. Chair, based on some information I'll just find. Member for 𝙍𝙍, can you just clarify for me exactly what you were looking for?
So I'm after, within the agency, Attorney General and Justice, how many committees are there? How often do they meet? And has there been a quorum at those meetings?
Apologies, I thought you meant of the one committee that we originally spoke about.
No.
Yeah, there is quite a bit of detail in that. I could read it all out, but that might take a while. I'm happy to take it on.
Attorney General, Member for 𝙍𝙍, please restate the question for the record.
Attorney General, could you please provide the number of committees operational within the Department of Attorney General and Justice, how often they meet, whether or not there has been quorums or not, please?
Attorney General, do you accept the question?
Yes.
The question asked by the member for 𝙍𝙍 of the Attorney General has been allocated the number 5.5. Are there any further for yourself, Member
So
for 𝙍𝙍?
just on the Child Death Review Committee, Attorney General, I understand that there has been no work to date by the government to pursue recommendations from committee members to fill positions.
Thank you for the question, Member for 𝙍𝙍. We are still doing the work involved to determine we'll look at, I guess, the outputs and the all the meetings that happen around that particular committee, and to work out what we need, what works, what doesn't. Like I said, that particular committee, there also has a coroner's report that's done for every death, including a child's death. And so we're looking at that. We will see if we need to make any changes to that particular act or that particular board. But there's been no changes so far in that board in this period.
So, Attorney General, was there no consideration to appoint interim or temporary members to continue the work of the Child Death Review Committee because there are 10 child deaths that have not been reviewed? Was there any consideration to have interim or temporary members until a review was undertaken to provide a different pathway?
Thank you for the question, Member for 𝙍𝙍. When it comes to child deaths, the coroner does do a report, and so that information is available to us as government.
Sure, but Attorney, it's statutory under legislation that this committee needs to meet. This committee hasn't met. there are 10 child deaths and it has still not met?
Member for 𝙍𝙀𝙇𝙀𝙍, for clarification, that committee has met once during the reporting period.
Once. And when was that, Attorney?
I don't have the date of that, but I am happy to take it on notice.
Member for 𝙍𝙀𝙍, please restate the question for the record.
Could the Attorney General please provide the date that the Child Death Review Committee last met?
Attorney General, do you accept the question?
Yes.
The question asked by the member for 𝙍𝙍 of the Attorney General has been allocated the number 5.6. Member for 𝙍𝙍?
No, that's it.
Member for Johnston?
Thank you, Chair. I have some follow-up questions for the member for Karama, but just on that last point from the member for 𝙍𝙍. In terms of the review of boards and committees, you talked a little bit about that. Can you explain or let us know who's undertaking the review, what process there is around all those reviews and all those, boards and committees?
That's an internal review run by the agency to show me all of the workings of each board, and then we will then determine if there are any changes to be made, and if they are, what recommendations they provide to me, and then some decisions will be made.
Will the affected bodies be consulted as part of that review?
I think it's not a generic answer to that, because I have a number of boards and committees across the portfolio. They are all function differently, and I think I wouldn't want to just generalise and say yes or no either way. I think it would be very dependent on the board, what its function is and how it works.
So, for example, with the Youth Justice Advisory Committee, will affected bodies be consulted?
Thank you for the question, Member for Johnston. That particular committee sits under the corrections portfolio, so it's not an example that I can refer to.
Okay. In relation to follow-up questions from the member for Karama, can you tell us on remand how many people are currently serving more days than they would be sentenced in territory jails?
Thank you, Member for Johnston. We do have Mr. Chris Cox from the courts area that has a bit more of that data available. I can either take it on notice, or you can ask it in the courts output if you wish. I don't have it right here. Sure. That's all.
I'm happy to take it on notice just to make sure that it gets covered. Yeah.
Member for Johnston, please restate the question for the record.
On remand, how many people are currently serving more days than are sentenced in territory jails?
Attorney General, do you accept the question?
I just need to make a clarification about the question, just for some of the specifics around it. We have the data on how many people have been sentenced and time served. I just don't know if we have that correlation that you've mentioned specifically. Would that be the data that you are after?
The data I'm after is whether or not people are spending more time on remand than they would if they were sentenced.
I guess it's a hypothetical, because we don't know what the sentence will be and how many days they will get by a judge. So it's a hypothetical and tricky question to answer without knowing exactly what that is. I guess if you're looking backwards to see, then that's data that would have to be pulled from lots of different areas, I guess. But again, Mr. Cox would be able to assist with that question. I just don't want to paint the illusion that I have all those exact facts when maybe they're slightly different in terms of the way it's asked.
Okay.
Through the chair, it's time served that you're asking for.
Thank you.
Versus,
yes. Yeah.
Thank you, Member for Guyula. Yeah, so I accept that question with time served.
Thank
Okay,
you. Member.
can we restate the new question?
On remand, how many people?
I might ask Member for Guyula if you could outlay how the question could be.
Got to remember what I asked. The question is, can the Attorney General provide information or data around time served versus the amount of time people have been on remand? Because, Member for Johnson, you're wanting to understand when the courts sentence someone, are they going back into prison or have they already served time being on remand?
Yes, and I'm also interested in knowing whether they are serving more time on remand than they would be had they been sentenced, which I think is what the Attorney General said is hypothetical.
It's the would be that, because it's, would be, could be, should be.
Yeah. Okay.
The second part would be hypothetical, but the first part is the data is telling you how long and whether or not after their sentence they're being incarcerated or their time on remand is accounting for time served.
Okay.
What he said.
Yeah.
If we can provide that,
Yeah.
Mr. Chair,
Okay.
we will, definitely.
Thank you. The Attorney General accepts. The question asked by the member for Guyula of the Attorney General has been allocated the number 5.7. We have 1 minute. Member for Johnston.
How many people have pled guilty before trial for each month from October until now?
Thank you for the question, Member for Johnson. Yeah, that is quite a bit of detail, but I'll take it on notice. If we can get back to you before the end of the session today, we will. But yeah, otherwise, we'll take that one on notice, Mr. Chair.
And to add to that question, the second part is, can you confirm those statistics also across the same months in 2023 and 2024?
Attorney General, do you accept the question? Over to you, Attorney General. Do you want it on notice?
Can we restate the question so
Yeah.
I can hear it?
Member for Johnston, please restate the question for the record.
How many people have pled guilty before trial for each month from October until now? And can you also confirm those statistics across the same months in 2023 and 2024?
Attorney General, do you accept the question?
Yes.
The question asked by the member for Johnston of the Attorney General has been allocated 5.8. The time is now 12:01. We will break for 30 minutes, returning at 12:31.
Is this lunchtime?
We'll now re-adjourn. We are still on questions on the opening statement. Are there any other questions?
I'm mid.
Member for Johnston.
Thank you, Chair. Just continuing with some follow-up questions from the member for Karama. Earlier, I think in answer to that, you said that there's 290 remand cases are being reviewed, of which 240 are finalised. I think you said 104 are guilty pleas. That means that 136 had a different outcome. Could you please break these down for the committee?
Thank you, Member for Johnson, for the question. You are right. Of those cases, I think it was about 72% of those were resulting in guilty. I'm just going to see if I've got a breakdown of what exactly the other ones were, but they are made up of a few different things where they are either, move on to a more complex part of a case. Actually, I do have some information here. Okay. Yeah. So, like I said, the team reviewed and finalised just under 200 outstanding case files. Of these, 89 files with open representations were identified as already being substantially finalised, 66 of which resolved via a plea of guilty. 78 matters resulted in appropriate early guilty pleas. 12 were pending a response to an appropriate offer. 16 were marked as ready to be listed for hearing, and 6 matters were withdrawn.
Thank you. Can you just say the figure again? What did you just say was guilty? I had a different figure written down here.
It's okay. Of the 289 files with open representations were identified as already being substantially finalised, 66 of which resolved via a plea of guilty, but 78 matters resulted in appropriate early guilty pleas. 12 were pending a response to an appropriate offer.
Yeah, sorry, Attorney, I think my question wasn't clear. I had written down that you said 290 cases are being finalised. Is that the data that you're working off there?
So it was 200 in that reporting period to the 31st of March.
Yeah.
So that's what I'm reading from here in this particular breakdown. But we know now that it's 290 so far for the year to date, I guess.
So from an extra 90 from March to date?
That's right.
Thank you. And just given I wonder if you've got any information on the impact on court wait times since the new bail laws came into effect.
I'll have Mr. Cox at the table with me when we get to that output, if that's okay. He definitely has a lot of that other data available.
I'm happy to move on.
Okay. Member for Mulca, do you have any other questions? Are there any other questions on the opening statement?
I just had one question, Chair. Thank you, Chair. And thank you, Attorney General. Attorney General, your office received 2 written questions, written question 70 and written question 81. Given that written questions, the answer is supposed to be given back to the person that gave it to you within 30 days, why were those 2 written questions after the 30 days?
Thank you, Member for Daly, for the question. So my department prepared responses to 2 lots of written questions from the opposition within 3 months of each other. The first one coming through, I think, in December and then in March, to which they have both been completed. It's been convention over many years that the work gets done and put forward into back to the opposition, ready for estimates. And I note that by doing both lots of written questions with only 3 months apart, it did actually create a lot of extra work, costing the taxpayer a lot of extra money, which is unusual. And when we were in opposition, we used to ask at once and we used to get the information very late as well. But we were still able to ask the questions we needed to during the estimates process.
So it's part of normal practice to put written questions to the government before estimates. So I'm just trying to get an understanding of, we've had the Chief Minister on now, we've had the Deputy Chief Minister on, we've had the Treasurer, all those ministers have replied to those written questions after the 30-day period, but replied on the day of estimates, including yourself as Attorney General. So I'm just trying to get an understanding of why on the day when those questions are being asked by Territorians and you've come into government of being transparent and open, you've then given the answer to those questions on the day of estimates when you're before us.
Thank you, Member for Daly, and I think you'll find we are being transparent. We're here in estimates, explaining to Territorians what we're doing as a government, but also answering the questions from the opposition and the crossbench. We've been very open about that and clear. We're happy to take any questions, and if we don't know the answer, we will come back to Territorians about that. I note that when the former government was in power, they regularly provided those written questions either well past the time.
Through the chair,
I'll take that up. Attorney General, as I've indicated, we won't be going back to any other estimates hearings. I wasn't at any other estimates hearings. We'll just be focusing on the estimates hearing now and this Parliament.
Thank you, Mr Chair. The opposition has put forward 2 lots of written questions leading into estimates, one in December, one in March. Both of those our agencies spent a lot of time working through to give the answers. I believe it was about $400,000 in taxpayer money for hours spent working on the 2 lots of those written question answers. They have been provided to the opposition. We are here today answering further questions in addition to any follow-up questions that might have been responded to in the written questions.
Okay, so what I'm trying to get at is you send the questions through the morning of estimates, which doesn't allow opposition members to look through those answers to then do any follow-up questions. So I'm trying to get an understanding of why they were provided on the day of estimates, because the whole point and the role of the estimate committee is to scrutinise the government around the budget. So when did you receive the answers back to those written questions from the department, your ministerial office?
Thank you, Member for Daly. Of course, we handed down our budget in May. That was quite some time ago now, so there's a lot of budget books that were circulated on that day where opposition and crossbench members can work through those budget books to identify the questions they'd like to ask. We received all of those, the first lot of written questions, which we thought would be the estimate questions in December, based on whole of agency
Through the chair,
information.
I'm just wanting to know when you received written question 70 and written question 81. When did the ministerial office receive the answers to those questions? That should be it should be a date attached to it. I understand when written questions go to the minister, it goes through Secretariat, down to the department, back up through Secretariat. So there would be a timeline of when that received, and you should have that information in front of you. So I'm just wanting to know when the ministerial office received those written questions.
Thank you, Member for Daly, for the question. So when the department spent all those additional hours preparing the second lot of written questions after the first lot had been asked 3 months earlier, that information, you're right, comes to the Minister's office. I read through all of that information and then
Thank you. I'm just wanting
approve
through
it.
the chair. Just wanting a date from when the ministerial office received question 70 and 81. I don't need the spiel. I just need to know when you received those written questions.
Thank you, Member for Daly. Attorney General.
Thank you, Mr Chair. Thank you for the member for Daly for the question. The date is whatever date I received it, and I would have looked through it and decided that they were ready to be put to the registry to go back to opposition. And I did that once I was satisfied that the written questions had been completed.
So you don't have a date from when you received it from Secretariat because it would be recorded?
I received the written questions from the agency. I read through them.
It goes
I
through
provided
Secretariat.
them.
Is there a proper process? So you'd have a date of when you received it from your ministerial office? That's usually the process.
Thank you for the clarification. The date in which it would have gone from registry to the opposition is obviously the date you received it, I assume.
I'm not asking about when we received it. I'm asking about when you received it from the department. The ministerial office received the answers to the question from the department.
I received them within a time frame after the department and agency had gone through all of those questions. I then read through them all and signed them off and gave them to registry to pass to the opposition.
Thank you. Are you able to take that question on notice? And I'm sure you could go back and find out a date.
Can you be specific about the exact date? Because there's a number of moving parts with written questions, with answers, with the way which they go through.
So the question is, as I've just stated before on a couple of occasions, was when did your ministerial office receive the answers to written questions 70 and 81. And then, so that's the question when your ministerial office received it from the department.
Mr. Chair, I feel like I've answered that question, so I don't really feel...
She hasn't answered it.
Committee, I've noted it. Attorney General, you are free to accept or not accept the question. So we've restated the question. Attorney General, do you accept the question?
Well, I feel like, Mr. Chair, that I've answered the question in terms of the process, about how it worked in my office at that time, the fact that
Chair,
I checked through that information before I sent it on.
It was pretty straightforward. The question, it was a date on when her ministerial office would have received the answers to those questions. It's not like, so she hasn't, I haven't heard you say a date from when you've received it, so you haven't answered the question.
Attorney General.
Mr. Chair, I do think I've been through and answered the question.
So that means no.
You're not taking on.
All right.
All right, we will move on. Are there any other questions on the opening statement? Okay. The committee will now consider the estimates of proposed expenditure contained in the Appropriation Bill 2526 as they relate to the Attorney General's Department. Are there any agency-related whole-of-government questions on budget and fiscal strategies? Shadow Minister. Are there any other questions? That concludes consideration of agency-related whole-of-government questions on budget and fiscal strategies. The committee will now consider Output Group 1, Legal Services, Output 1.1, Solicitor for the Northern Territory. Are there any questions?
Yes.
Member for 𝙍𝙬𝙍𝙎.
Thank you. Attorney General, how many matters were briefed out by the Solicitor for the Northern Territory to external counsel in the reporting period?
Can I just clarify, Member for 𝙍𝙬𝙍𝙎, do you want to know how much has been briefed out but for whole of government through the SG or just for the SG?
So what I want is how many matters AGD have outsourced and then how many whole of government have been outsourced.
So both?
Yes, please.
Thank you, Member for 𝙍𝙬𝙍𝙎. As you know, the Solicitor for the Northern Territory does outsource legal services to private law firms under the NT Legal Services list and also coordinates the briefing of council and government. Where SFNT cannot take on a matter due to capacity or conflict, then government needs to engage outsourced legal services, which you know. So in the reporting period, 92% of outsourced matters went to local firms. More matters were outsourced to local firms compared to 23-24, and there was an increase of 31 matters from 356 matters in 23-24 to 387 in 24-25. Law firms on the NTLSL, which is the NT Legal Services list, grew from 43 in 23-24 to 46 in 24-25, which did provide the government more options for private legal services and advice. One law firm removed themselves from the list, which was Squire Patton Boggs. The reason for this was the closure of their office in Darwin. 3 firms were added to the list. One of those firms is local and 2 of them are from interstate. Also, one firm closed their office in Darwin, so were reclassified as an interstate firm, and that was Minter Ellison. The numbers I'll take you through. In 24-25, yes. The number of matters outsourced was 422. The breakdown of those, the types of matters, litigation matters included 282. Child welfare was 134. Commercial matters was 140. Contract procurement was 85.
Great. And how many of these matters were briefed out to Maley barristers and solicitors?
Member for Guyula, I've just looked through the list for the AGD briefings out, and there is none for Maley's lawyers. But what it doesn't include there, and I don't have that right now, is the whole of government legal briefings.
I'd like you to take that on notice, please.
Yeah.
Member for Guyula, please restate the question for the record.
Thank you. Attorney General, could you please provide, if any, the number of matters briefed out to Maley barristers and solicitors, please?
Attorney General, do you accept the question?
Yes.
The question asked by the member for Guyula of the Attorney General has been allocated the number 5.9. Member for Guyula.
Thank you, Mr. Chair. I have no further questions. I would like to just put on notice that I'd like the Anti-Discrimination and the Children's Commissioner.
Acknowledged. Are there any other questions on output 1.1? Member for Johnston.
I think this fits here. Just following on from that question from the member for Guyula, can you explain what protocols are in place to ensure the independence of the Solicitor for the Northern Territory when legal matters involve potential conflicts between government departments or statutory officers?
Thank you for the question, Member for Johnston. Given it's operational in the Solicitor for the Northern Territory area, I'll hand over to Gemma Lake, the Chief Executive Officer, to explain.
Thank you for the question. Gemma Lake, Chief Executive Officer. Can I just get an understanding of the particular question? Is it around, I can explain how the Solicitor for the NT receives matters and then either makes a decision to keep them in-house or outsource them. But if there's a particular question about conflict...
I'm interested specifically in how conflict of interest is managed. So is that too broad?
If you can be specific in terms of in what area that conflict is managed, I guess, because there's a...
I guess when there's potential conflicts between government departments, statutory officers, when you're providing legal advice.
Thank you. I'll hand to Gemma Lake, Chief Executive Officer.
Thank you, Gemma Lake, Chief Executive Officer. So the Solicitor for Northern Territory, on receiving your instructions, has a process where it conducts a conflict check to determine if there's previous matters or other matters. Lawyers are also required, as lawyers and as public servants, to declare any conflicts of interest that they might have. That's determined on a case-by-case basis, depending on what the circumstances are. If the SFNT, for example, was representing a particular agency on a matter and then perhaps a statutory entity had a matter that involved that agency, SFNT would not be able to represent both of them, as an example, because they would be conflicted, and that's where we would look to outsource matters under the legal services list. I'm hoping perhaps that might answer the question.
Yes, that broadly answers it, thank you. And if there are declarations of conflict of interest, are they publicly available? Not in terms of department. I understand what you just said. For example, if SafeNT wouldn't, yeah.
Those would be managed internally because they would be declarations by employees and we would not make them public. No.
Thank you.
Are there any further questions for output 1.1? Member for Nightcliff.
Hi. I'll just check first that I can ask this one here. It's just about the budget for legal aid. Is that under legal services? can sort of ask.
Thank you, Member for Nightcliff. I believe that's in output 2.
Oh, sorry. All right.
Yeah, under 2.1.6.
2.1. Okay, thank you. Then I'll just move on to another one. I think comes under legal services. It's about since the closure of the youth detention centre in Alice Springs, all youth detainees are now held at halts outside of Darwin. My understanding is that this means they can only engage with their legal practitioners over video conferencing. Could you confirm if that's true, or is that a different output?
Thank you, Member for Nightcliff. We don't represent those people that are in those facilities. That's under corrections, but also it's NARJA and Legal Aid who are the ones meeting with the people in there. So it's not part of this government's remit, if you like.
Oh, okay, so you wouldn't be able to talk about how... So I just assumed under legal services we can't talk about how people or youth are accessing their legal practitioners? No.
Thank you, Member for Nightcliff. I guess we don't represent the people, so it would be inappropriate, I guess, for us to talk about something that is not in our wheelhouse.
Okay. Are we able to talk about the access that people have, just like specialist services such as Congress, child and youth assessment and therapeutic programs, that assess, diagnose and treat young people with neurodevelopmental disorders like 𝙍𝙀𝙇𝙀𝙍, and how they are doing those over video conferencing?
Thank you, Member for Nightcliff. Because those video conferencing meetings or personal meetings happen in the corrections facility,
Okay.
I can't actually answer those questions under this portfolio.
Okay, thanks. All right, I've got some others, but a different output. Thank you.
Are there any further questions on output 1.1? That concludes consideration of output 1.1. The committee will now move on to output 1.2, Solicitor General. Are there any questions? That concludes consideration of output 1.2. We will now call for questions on output 1.3, Crime Victim Services. Are there any questions?
Yeah, I just have one question about the victim services, sorry, and that was the money in the budget that is being allocated. What work is being done to ensure that victims of crime in remote Aboriginal communities have access to the information and support to access the same level of service?
Thank you for the question, Member for 𝙍𝙬, and I will hand over shortly to Ms. Catherine White, who's the Director of the Crimes Victim Services Unit. But just before I do, you would know that recently in Parliament we increased the Victims Levy by up to 40% to try and have more funds available for those victim services. And I'll hand over to Catherine White to explain some of those services.
Catherine White, Director of Crime Victim Services Unit. CVSU has staff who are based in Darwin, but however we work with a number of stakeholders to support applicants throughout the Territory to be able to lodge either an application for financial assistance or an application for the Victims Register. We are doing a number of things to be able to improve that, and one of those is about developing some resources to help victims better understand their rights and what is contained in the Charter of Victims' Rights, and that will be made available to all public servants and also the external sector to help people understand what their obligations are and what the rights of victims are. We're also looking to institute a community of practice for victim services so that we can help victims, we can help the sector better support victims and better understand what rights and what facilities are out there for victims across the Territory.
Sure. So through the Attorney General...
Sorry, Member for 𝙍𝙬, just your microphone.
Thank you, Mr Chair. Through this particular program and investment, is there any work being done by the agency or by the Victims of Crime Support Unit in remote communities around awareness? And of this portion of funding, how much of that goes to Aboriginal victims?
I'm happy for Ms White to answer that question.
Catherine White, Director, Crime Victim Services Unit. In terms of the amount of payments that are made and how many of those are made to Aboriginal victims versus how many are made to non-Aboriginal victims, I do have some data on the total number of payments. I'm uncertain whether that was made, whether that has been done on the basis of whether a person's ATSI status. But no, I can tell you that we have awarded $4.3 million in the reporting period. I would have to take on notice how much of that was made to applicants who identify as Aboriginal or Torres Strait Islander.
Thank you.
Are there any further questions on output 1.3?
No.
That concludes consideration of output 1.3 and output group 1. We'll now proceed to output group 2, strategic policy services, output 2.1, legal and strategic policy. Are there any questions? Member for Nightcliff.
Oh, thank you. Thank you. In the budget, there was almost $9 million for legal aid NT for their demand pressures in 2024-25, and in 25 to 26, this will be just $5.5 million. I'm assuming this is a top up of the funding that comes from the Commonwealth to fund our public legal services.
Thank you for the question, Member for Nightcliff. So the money we've put in the budget, the $5.5 million ongoing, that is in addition to the Commonwealth funding, and it's from the Northern Territory Government. It's specifically to address those demand issues that we did see over the last number of years, but in particular the last 12 months. And so that allows for legal aid to have that certainty so they can continue to deliver services in a time where demand is growing.
Thank you. Are you able to describe what exactly that covers, the $5.5 million?
Thank you, Member for Nightcliff, for the question. So the funding that the Northern Territory Government provides and the additional funding of the 5.5 covers that representation of offenders who in the criminal space, very specifically the criminal space, but also it includes domestic violence legal services as well.
Okay, thank you. Are you able to tell me through the chair how much the Commonwealth and NT governments will spend together on legal services like 𝙍𝙀𝙇𝙀𝙍 and NT legal aid?
We're just adding that up for you.
Sure, thank you. I can just get it on notice. Is that easier?
We're just getting that for you.
Sure.
Won't be a moment.
Okay.
Thank you, Member for Nightcliff, for your patience. I might actually take that on notice. Just there's a couple of little tricky parts about it.
Sure, thank you.
Member for Nightcliff, please restate the question for the record.
Sure. It was, could the minister tell me how much the Commonwealth and NT governments will spend together on legal services like 𝙍𝙀𝙍 and NT legal aid?
Attorney General, do you accept the question?
Yes.
The question asked by the member for Nightcliff of the Attorney General has been allocated the number 5.10. Member for Nightcliff.
Thank you. And has there been any increase in funding either from the NT government or the Commonwealth government to ensure that legal practitioners and health practitioners are able to travel to Holt's facility? This is where I was getting before about the youth that are getting transferred for them to be able to conduct assessments and progress legal matters?
Thank you, Member for Nightcliff. So just to be clear, the Northern Territory Government funds legal aid for those criminal matters, and the Commonwealth funds funds NARJA for their legal services. And then the Territory will give that funding to legal aid to deliver those services in a way that works best for them. And the same with, I guess, Commonwealth giving the funds to NARJA. So under the National Access of Justice Partnership, the funds going from the Commonwealth to NARJA have increased, and then they will use those funds based on their operational requirements.
Okay, thank you. And just on that, on the National Access to Justice Partnership, how much of this funding will the Northern Territory receive each year over the next 5 years?
Thank you, Member for Nightcliff. The NJAP, as we've been calling it, the funds coming from the Commonwealth to the Northern Territory in 2025-26 will be a total of $61.921 million. In 26-27, it'll be a total of $63.283 million. In 27-28, it'll be a total of $64.551 million. In 28-29, it'll be a total of $65.843 million. In 29-30, it'll be $67.162 million, which the total of the 5 years is $322.760 million.
Thank you so much. How will the funding be distributed to each different type of service?
Thank you for the question, Member for Nightcliff. So looking at 2025-26, legal aid commissions will receive $10.711 million. Community legal centres will receive $2.095 million. Women's legal services will receive $6.385 million. Aboriginal and Torres Strait Islander legal services will receive $27.744 million. Family violence prevention and legal services will receive $13.960 million.
I've just got an idea through the Chair. Do you have that breakdown, so that breakdown that you're reading out now for every year?
I do. I can take you through that.
Could I just get on notice? Yeah. Save you reading it all out.
I am happy to take on notice and give that to you. There is a website that's public that you can get that on there. It's a Commonwealth website called, I'll just get that address for you if you like. We might have to Google it for you, Member for Nightcliff, but it's definitely there.
Okay. Thank you. And is that decision about how the funding is allocated, is that made by the Commonwealth or by Northern Territory Government?
That's correct. It's made by the Commonwealth.
Thank you. It is my understanding that there have been changes to what expenditure can be supported as under the NAJP contract. For example, things such as rental assistance for remote areas are now prohibited to some Aboriginal-led legal services. Are these changes due to Commonwealth restrictions or have they been introduced by your department?
Thank you, Member for Nightcliff. So the scope of the NAJP is defined by the Commonwealth, but to explain that a bit further, I might pass to Ms Jeanette Hannigan, the Executive Director of Strategic Policy Coordination of our department, to explain what that means.
Thank you for the question. Thanks, Minister. Janet Hannigan, ED of Strategic Policy Coordination. So the NAJP agreement, which is also available online, sets out a very clear scope of what the funding is intended to deliver on. in its renegotiation, it also made specific focus on gender-based violence. So it is quite clear in terms of its scope, but also allows for flexibility of organisations to take reasonable discretion in terms of how they then deliver their services with the funding that's provided.
Okay, thank you. So under the previous Commonwealth funding arrangements, these organisations had the autonomy to make decisions that directly supported their wellbeing, retention and upskilling of their workforce, many of whom are Aboriginal women living and working in remote areas. Without these supports now, though, how are these organisations expected to attract qualified legal staff and retain them in remote communities or offer basic wellbeing and professional development opportunities?
Thank you, Member for Nightcliff. I might pass to Jeanette Hannigan, Executive Director.
Thank you for the question. Actually, as part of the NAJP funding, there was a specific stream regarding pay parity, and that certainly goes to organisations being able to utilise those funds to manage their workforce in terms of recruitment, retention and development. So, and certainly the manner in which we are working with those organisations, we are leaving it very much open to them in terms of how they manage that.
Thank you. NAJA, for example, are able to provide their staff with airfares. Women's Legal Services can send their staff to conferences, and the NT Legal Aid Commission, as well as other NT Community Legal Aid Services, all offer relocation assistance. So these Aboriginal-led family violence legal services are being, it seems like they're being held to a more restrictive standards now under this NAJPC contract, while other legal services appear to maintain flexibility in how their funds are used. Would that be accurate or no? No.
Yeah, thank you, Member for Nightcliff. Obviously, it is a Commonwealth agreement, but I will hand over to Jeanette Hannigan, Executive Director.
Thank you, Minister. No, there is no restriction as best as, or any delineation between different organisations and subsectors. It's quite broad, deliberately at the Commonwealth level, and certainly from an NT perspective, that's how we are administering those funds.
Are there any other questions for Output 2.1? I'll now call for questions on Output 2.2, Criminal Justice Research, Evaluation and Statistics. Are there any questions? That concludes... oh, sorry. Sorry, Member for Johnston. I misread that cue. Member for Johnston.
Thank you, Chair. Minister, can you briefly, I'm happy for it, to outline how criminal justice research and evaluation findings are being used to inform policy and legislative decisions within your portfolio, in particular your recent legislative changes and also the trial of the OC spray?
Thank you for the question, Member for Johnston. As you can see from the officials that are here today, there's a lot of expertise in a lot of areas around the legal and justice system. But in the case specifically, I might hand over to Miss Carolyn White because she, as the Director of Criminal Justice Research, she's got a lot of information that she's able to share that might assist with answering the question.
Carolyn White, Director of Research and Statistics. So some of the ways in which we're using our resources are to monitor the effects of legislation, so what's happening in terms of bail, what's happening in terms of numbers of people charged, numbers of people sentenced, numbers of young people that are coming before the court, numbers of times different facets of the legislation are being used.
Sorry, Michael, my question is how is that information being taken into account into the development of new legislation and specifically as an example into the proposed trial of OC spray?
Thank you, Member for Johnston. So the way in which we are developing or putting forward new legislation. Firstly, in the first few tranches that we've done, obviously leading out of the back of the election, was that we made a commitment, and so we went to work on getting that legislation prepared. And the Attorney General's Department, along with other members of government agencies, all contribute to putting that forward. And they have input into that as to what might work and what might need more work. And so we take on board that advice from each of the people involved. Of course, we want to make sure that the intention that we have as ministers in terms of putting forward changes in legislation does have the desired outcome, which is why we do involve the public servants who work across the agencies that particular legislation impacts. So specifically in relation to the OC spray that you mentioned, that sits with police under the Fire and Weapons Act and policies around that. So I won't speak to that specifically because it's not within the AGD portfolio. But I guess that was an explanation of how we form or create that legislation to put forward to Parliament. And of course, then it goes through the process that it does through Parliament.
Thank you, Minister. And is any of that evaluation, is any of that publicly available in terms of what's used to inform when evaluation is used to inform lawmaking? And I understand, Minister, that much of the law you've passed has not been subject to a pre-evaluation process, you've said, but when it is any of that evaluation publicly available?
Thank you for the question, Member for Johnston. I guess legislation and amendments to legislation take all sorts of forms in terms of their creation. If there's a have your say or a wide public consultation, then there might be elements of that legislation which is public, and that has certainly been the past historically, in that way historically. And there are many factors that go into that as well. And so I guess it's not always made public. There's often, conversations that happen across agencies and across ministries and through the legislation process. But there's always an opportunity for everyone to put forward either views or feedback or their own evaluations or evidence that they have once it is tabled and introduced into Parliament. Of course, we know that usually sits on the table for 30 days or more, and in other cases it might be maybe not, it might be an urgency, but that's the general way in which the legislation is done. And I might just hand over to Gemma Lake, my Chief Executive Officer, just to add a little bit more about that.
Thank you. Excuse me, Gemma Lake, Chief Executive Officer. There is an evaluation framework that sits with the Department of Treasury and Finance that applies to all government agencies, and we work under that framework. When we do a formal evaluation under that framework, it is, once it's complete, it is published by the Department of Treasury and Finance. So that's just a bit of additional information.
Thank you. And just one final question. So on what basis, Attorney General, would you decide to develop a law based on evaluation and research? On what basis would you decide to just go ahead and do it?
Thank you for the question, Member for Johnston. I guess that would depend on what's involved, but I will say from the outset that this first 10 months of legislation that we've introduced in the main has been off the back of a territory election. And so we took to the election the commitments that we would make if we were to be elected. And of course, in being elected and having the 17 seats, we are now delivering on that, which means the evaluation part of it happens as we're starting to work through that legislation. And like I said before, the different people in the agency who contribute to creating that legislation and how that works through the process. So I think there's been other pieces of legislation which are might have been worked on for a very long time. I guess I don't want to preempt debate, but we had, say, the defamation legislation, which we put forward. That was legislation which had been worked on for a very long time in the background. So we, didn't go out to public consultation about that because it's been in the works and it's, national, and there's all sorts of reasons why. But I guess the point is that it really does depend. And so far, most of the work we've done was on the back of our election commitments.
Thank you. So just to be clear, not based on any evaluation, but based on the election.
There are certainly things that are taken into consideration about the legislation we put forward. There's many facets of putting that together, and there's many people involved in pulling that together, including feedback from the community and the people who are working in that particular space. And that's the work of government. That's the work of creating legislation, which eventually ends up in Parliament for the 25 of us parliamentarians to debate and then ultimately pass or not.
Are there any further questions on output 2.2? Member for Nightcliff.
Thank you very much. What are some of the issues that your department faces when establishing data and reporting requirements for a new project?
Can I just get a bit of clarification or context?
Okay, sure. I just want to, if you could maybe just step us through how the unit is involved in the development of data requirements for monitoring of new projects.
When you say projects?
I guess like new initiatives like the OC spray.
Thank you, Member for Nightcliff. I might hand over to Ms. Carolyn White, the Director of Criminal Justice Research, to answer that question.
Thank you, Minister. Thank you, Member for Nightcliff. Carolyn White, Director of Research and Statistics. So in developing reporting and data requirements, usually we would start by considering what questions we're trying to answer, what the issues or aims or objectives are. And so basically setting out a monitoring and evaluation framework up front. From that point, then we work to what the indicators are that we would like to use to be able to answer those questions. And at that point, that's when we start looking at the actual data and whether we have that data available. In some cases, it might involve a project with Department of DCDD, sorry, to set out the IT requirements if the data isn't currently being collected in a way that we can report it. In other cases, it might be just that we develop a new report based on existing data if we have it.
Okay, thanks. In the interest of time, we'll move on.
I will go back to output 2.1 for the member for Mulca. That is only because we just had a prearranged understanding. And so, member for Mulca, apologies. You did make me aware of an output for 2.1, so please ask the question.
Thank you, Chair, to the Minister. For the 25-26 budget, has there been an increase rather, in funding for services that provide alternative dispute mechanisms, such as the Community Justice Centre, arts, mediation, or other alternative dispute resolution programs?
Thank you, Member for Mulca. Just for clarification, that is output 3, but given you've been waiting a long time to ask that, I think we can attempt to answer it here. Yes. Just one moment.
Just do that one.
Member for Mulca, I will throw to Gemma Lake, the Chief Executive Officer, Attorney Generals.
Thank you, Attorney. Thank you, Member for Mulca, for the question. Gemma Lake, Chief Executive Officer. Excuse me. So the Community Justice Centre, I can confirm that their baseline funding has not changed. It's remained the same in this budget. There is some additional funding for the Community Justice Centre, so I'll just give you some information on that, Member for Mulca. So the CJC, or the Community Justice Centre's function, is to reduce the pressure on other justice services through the resolution of disputes outside the justice system. At the moment, the Community Justice Centre is involved in a number of additional projects which are funded through Commonwealth funding. They are the Barkly Regional Deal Community Mediation Initiative, the Town Camp Peace Project in Alice Springs, the West Daly Peace Project, and the Mabantua Alice Springs Peacemaking Project. I can provide some more information on the funding for those if needed. Member for Mulca.
Thank you. Thank you for
I
that.
can keep going.
That's all for the timing.
Are there any other questions for output 2.2? That concludes consideration of output 2.2. The committee will now move on to output 2.3, Aboriginal Justice. Are there any questions, opposition? Are there any other questions? Member for Mulca. Yeah? 2.3, correct.
He's appeared. Yes.
Tell him.
Thank you, Chair. To the Minister, how many staff are working as part of the Aboriginal Justice Unit, AJU? What salary level are they paid at? Right.
Thank you, Member for Mulca, for the question. I might introduce Mr. Robert Pocock, who is the Director of the Aboriginal Justice Unit, Attorney Generals, to help answer that question for you.
Thank you, Minister. Robert Pocock, Director of the Aboriginal Justice Unit, and thank you, Member for Mulca. There's currently 5 FTE employed in the Aboriginal Justice Unit. That's 6 staff, 2 of them part-time, so that is 5 FTE in total. There's Executive Officer 2, that's myself. An Executive Officer 1, that's a Deputy Director. A Senior Administrative Officer, an AO6, an Administrative Officer 5, and an Administrative Officer 4. And the AO5, 6 are project officers, and the Administrative Officer 4 is an Executive Assistant. Thank you.
Yeah. Are there more questions on this output? No. We've got time.
Yeah, sorry about that. Got myself tangled up here. But the Chair, the Minister, the next question is the Aboriginal Justice Agreement states by 2027 this agreement aims to, 1, reduce offending and imprisonment of Aboriginal Territorians. Early this year, the government supported this statement in the motion that I put up before Parliament. When this agreement was signed in 2022. Prisoner numbers were approximately 1,900. Today, prisoner numbers are over 2,800 and growing. Since signing the agreement, imprisonment has increased by approximately 47%. Can the Minister outline how the government will decrease or reduce, rather, incarceration by 50% within 2 years? How will you keep to the agreement, or is the government committed to continue, or untrue, rather? Sorry.
Thank you for the question, Member for Mulcair. Yes, the government does continue to support the Aboriginal Justice Agreement, and as you have mentioned, it does have those three aims, and they're aims that our government are also committed to pursuing, and we are continuing. We recognise that we may have a slightly different approach to how we deal with crime and the crime crisis that we've experienced for a long time and that we inherited. But we will continue to do that work. We continue to support the framework of the Aboriginal Justice Agreement, and of course there's endeavours, and they do line up with the platform that we have, which is to reduce crime, rebuild our economy and restore our territory lifestyle, to support medium to long-term solutions. We are developing, I mentioned in my opening statement, the Reducing Crime Strategy, and that focuses on prevention, accountability and consequences. And that is a comprehensive approach to tackling crime at its source. We've talked a lot over the last 10 months about addressing the root causes, and there'll be a focus on those root causes within that, as well as across a number of other agencies, of course, which you've no doubt heard all of the ministers talk about at every opportunity. So obviously we have those action items that had been implemented, so the community courts, which are operational, the alternatives to custody, which are operational. Sorry, I missed out on the law and justice groups. We had that conversation earlier today. There's 5 that are currently operational, and there's 1 that's being worked through the steps that are needed, and we're looking to evaluate the outcomes of all of those different parts of the Aboriginal Justice Agreement November 2025 to see whether it's making an impact, and we look forward to seeing what that evaluation review shows us, and I think I'll hand over, just to add to the context of all of this, to Robert Pocock at the AGU, because he's been working directly in this space, and so I'll hand over to him. Thank you.
Thank you, Minister. Thank you, Member for Mulcair. Robert Pocock, Director of the Aboriginal Justice Unit. So in terms of the reducing crime strategy, it's
No, keep going, sorry.
still under development, and consideration is being given to how the Aboriginal Justice Agreement can work within that strategy. There's clear alignment between the AJA and the strategy around prevention, accountability and consequences. And, for example, those initiatives currently on foot are law and justice groups, community courts and alternatives to custody.
Through the chair, could I just do a follow-up question? Just picking up on with your answer around prevention, Minister, from the Director of Mr. Robert Pocock. He talked about prevention, but all the 3 supposedly preventative measures he outlined is actually once a person is in touch with the justice system. So can you outline what other preventative measures you have before someone actually gets in touch with the justice system, and how that aligns through the AJA.
Thank you for the question, Member for Daly. As you would know, I guess crime prevention does sit across multiple agencies, and we all work hand in hand to be able to look at how we can address those root causes. Of course, the prevention of crime is important because obviously we don't want to see it in the first place. And the strategy itself, the Reducing Crime Strategy, which is being developed through the Attorney General's Department as the lead agency, but working hand in hand with other agencies. This strategy will focus on, and I'll just take you through a couple of the high-level plans supported by an implementation, which is going to focus on 5 strategic priorities. So we want to address the root causes of crime, hold parents and families to account, create a safer community, reduce reoffending and deliver effective justice, and reform the system. And so you can see by those 5 priorities that it will sit across multiple agencies. For example, police working out on the streets as they do, and parents and families under the Children and Families. We speak about a lot the circuit breaker program, and in education, the school truancy officers. So a lot of these things will all come together into this reducing crime strategy. Of course, there'll be law changes, but there'll also be all of the other mechanisms in place to allow us to continue to find what is causing the problems that lead people to crime, and work to reduce crime by making sure we're not having it in the first place.
Thank you. And just on that, one of the principles within the AJA speaks of the value and support of Aboriginal leadership and local decision making. So what are you doing as Attorney General, and who are you working with in that space within the AJA? What Aboriginal organisations, Aboriginal people are you working with?
Thank you for the question, Member for Daly. There are the 5 law and justice groups that were established, and we will continue to evaluate and monitor how they have gone. That's through the community courts.
So you haven't met with them?
So we had that conversation earlier about whether I've met with them or not, and that
was a no.
The work will continue.
Sorry, Attorney General, Member for Daly, if you have an interjection, please just let me know what it is, and if I need to address it with the Minister, we can go from there. Attorney General.
Thank you. And so I might hand over to Robert Pocock to talk about the things that is happening in the community with the Aboriginal Justice Agreement, and how that implementation is going, because it is an important part of reducing crime strategy, as well as ensuring that there are those sentences which are in line with a local community and the law and justice group within the community courts.
Member for Daly, any follow-up? Oh, my apologies. Attorney General.
Thank you, Minister. Thank you, Member for Daly. So the staff in my unit have been engaging with the law and justice groups, the 5 that currently exist, and their auspicing organisations since taking responsibility for law and justice groups from the Department of Chief Minister and Cabinet through the machinery of government changes. We also regularly engage with NAJA in terms of community court operations, and my staff have also attended with the community court registrar the communities where the law and justice groups are operating to assist with the provision of training around community courts. We also, until recently, had some staff in Alice Springs that were engaging every few weeks with the Law and Justice Group out at Kintore. So they would travel from Alice Springs and spend days to week at a time out there working to get that group the support it required to get it off the ground. Thank you.
Thank you, through the chair. But just to note, Attorney General, you haven't met with any of those law and justice groups, just your department, but you personally haven't met with any of those law and justice groups.
Thank you, Member for Daly. I'm looking forward to meeting as many of them as I possibly can over the coming months and years as we see the work that they've been doing. They've only been in operation a relatively short amount of time. As a new Attorney General, I've been focusing on the priorities of implementing a lot of new laws to fix the territory, and I make no
So law and
apologies
justice
for
groups
that.
aren't your priority, through the chair? Is that what you're suggesting there?
Member for Daly, we've got established if you feel the question's not being answered or you feel your question's being answered, there's a difference between putting through the chair and just saying it. So please bring up an objection with me and then we'll go from there.
Can I continue
Attorney
my
General.
question, my answer?
So through the chair, I just wanted clarification, like law and justice groups aren't a priority for you as the Attorney General. Is that what you're saying?
Mr. Chair,
Okay, we'll now allow the Attorney General to respond with no further interjection. Attorney General.
Thank you, Mr. Chair, and thank you for the clarification, Member for Daly. I didn't say that they weren't a priority. I have a very senior public servant who understands the history of the Aboriginal Justice Agreement and the unit and works closely with the law and justice groups in Mr. Pocock, who has just outlined the work that he and the department have already undertaken in that important space. I have colleagues who are ministers right up and down the spine of the Northern Territory who have met with law and justice groups before, and I trust the work that they have done in terms of chatting with them and understanding what is happening in some of those communities. And I look forward to personally going out and meeting some of the law and justice groups, sitting in the community courts to see how that goes. I make no apologies for the work that I've already undertaken since becoming the Attorney General and since the election. There has been a mountain of work, and I think our actions are proof that the mountain of work that we've already been able to deliver on continues. And so as a whole government and as a minister, we will continue that work. That will mean going out and visiting Territorians wherever they live, and we'll do that across multiple ministers at multiple times.
Can I follow up?
Yes, of course, and I do note too, the member for Mulca, so it's a follow-up question?
It's a follow-up question to his original question.
Yep,
thank you.
please, member for Justin.
Thank you, Chair. Minister, in the member for Mulca's question, sorry, part of that question was, can you outline how you'll reduce incarceration of Aboriginal people by 50% within 2 years? How are you planning to keep to that agreement?
Thank you for the question, Member for Johnston. It is a hypothetical question in terms of like what those results are going to be, but I will say that there are things that we are doing differently under our term of government, which was different to what the previous government was doing to reduce crime. And of course, you've heard us talk at length about those things that we have changed. And there's, we've just heard from Mr. Pocock about the work they're doing in the Aboriginal Justice Unit, about the Aboriginal Justice Agreement. You've heard me talking about the strategy that we're working on for the Reducing Crime Strategy and those areas that we're going to touch on. You've heard me talk about addressing root causes, holding parents and families to account. Some of that work's already well underway and, having real results. And so I think this is a government of action, and we have certainly showed in our actions that we are doing all of that work that is needed, and that work will continue.
Thank you. Through the chair, the question for the member for Mooka was actually how will you be reducing incarceration, not reducing crime? And it's not a hypothetical question. I'm actually interested in tangible answers. Thank you.
Thank you, Member for Johnston. And before I hand over to add a bit more detail around some of those specific areas, in particular the alternatives to custody, I'll say that they are a fairly new option for sentencing as part of those community courts. They've only been in operation for in some cases under a year and in some just over a year. And I went through those numbers before of the people who have appeared before those courts and where sentences have been delivered like to an alternative to custody. And that we also look forward to evaluating that to see what's working and what's not. So obviously we'll look at the data, we'll see where we're sitting with that target that was the original target of 2022, I think, in the Aboriginal Justice Agreement. I don't know if I've got that exactly right. It's been a number of years. But I'll hand over to Mr Pocock, the Director of the Aboriginal Justice Unit, to add to the alternative custodies, which is a different, which is what we're working to deliver for those alternatives in those areas under the Aboriginal Justice Agreement.
Thank you. Sorry, Mr Pocock, just before you do, is the alternatives, is that the only thing in train at the moment to try and reduce incarceration of Aboriginal people?
No, Member for Johnston, thank you for the question and clarifying it. There's a number of things that we're doing around reducing crime as an overarching theme, and it's across a number of the portfolios. Like I touched on, and we talk about in Parliament all the time, the circuit breaker program that has family responsibilities attached to it. I have touched on the truancy office, so getting kids to school. I mean, the Education Minister's on next, I believe, and she will talk about that. And of course, our law changes. You know, we know that if there's a reduction in crime, there's a reduction in incarceration rates. Like, that's what we want. So we will keep doing that work, and I don't know if you have anything else that you'd like to add, Robert Pocock. I'm happy for you to talk a bit more about the alternatives to custody.
Thank you, Minister, and thank you, Members Johnston. So I'll just run through the two alternative custody facilities currently operating in the NT. So there's the Life Skills Camp for Aboriginal Women in Alice Springs and the Aniliaqua Healing Centre on Groot Island for Aboriginal men. Both facilities are currently operated by Drug and Alcohol Services Australia. In relation to the Healing Centre, construction of that facility was completed in January 2025. The facility has residential capacity for 32 clients. Day programs commence in August 2024 upon completion of stage 1 of the facility. As at 31 March 2025, there were 17 clients undertaking day programs and case management at the Healing Centre. These clients will transition to residential programs with the commencement of residential programs on the 31st of May. Residential operations will scale up in 3 phases, 4 residents in June, doubling to 8 in July and 12 in August before becoming fully operational. And this is to allow testing and adjusting of programs. Day programs will continue at the facility in the meantime. Drug and Alcohol Services Australia was awarded a service delivery grant in December 2024 to operate the facility for a further 12 months to December 2025. The total amount of that grant is $3,012,168. Operational funding is available in each of the 25-26 and 26-27 financial years for that facility, as it is for the Life Skills Camp. The Life Skills Camp continues to operate with capacity for 10 women. A total of 42 women have completed the 6-month residential program since August 2020, with a further 7 clients currently nearing completion. Drug and Alcohol Services Australia is currently contracted under a service delivery grant to operate the facility to 30 June 2025. operational funding of 1.6 million per annum is available in each of the 25-26 and 26-27 financial years. And if I could talk a bit more about some of the outcomes we've seen out of the Life Skills Camp facility in terms of a comparison of female reoffending rates versus the reoffending rates for clients of the Life Skills Camp ATC. It's a bit complicated doing an apples-to-apples comparison, but I'll attempt it. The Productivity Commission defines reoffending as the proportion of people aged 10 and over who were proceeded against more than once by police during the year, the proportion of adults released from prison after serving a sentence who return to corrective services, either prison or community corrections within 2 years with a new correctional sanction, the proportion of adults discharged from community corrections orders who return to corrective services, either prison or community corrections, with a new correctional sanction within 2 years. That data hasn't been published yet for 24-25, so the comparison will be based on 23-24 data. It's available to us. As at July 2024, 39 women had successfully completed the Life Skills Camp Alternative to Custody program. Of these, 16 have reoffended, either proceeded against by police or returned to prison. There are a number of variables to consider in attempting to make a binary comparison between the reoffending rates of ATC clients and the female prisoners, as I'd noted. However, Carolyn White's team, the research and statistics, have provided a comparison, and the rate of female offending in the NT for 23-24 was 39.58%, whereas the rate of offending for ATC clients was 31.2%, outwardly demonstrating program success in reducing offending.
Can I just add there for your help, Member for Johnston, I think we all have the same goal to reduce incarceration and including of Aboriginal people. We know that the Productivity Commission had said, because NAJA put this in their media release just recently, that the Aboriginal people in prison in the NT increased by 40% from 2020 to 2024, and of course, you know, that's horrific that that's the number. And so we acknowledge that number and, of course, you know, want to make sure that they're not, it's not increasing. But at the same time, our priority absolutely has to be that if you are committing crimes, there needs to be consequences and accountability for that, because it's, you know, it's innocent Territorians and families just going about their day and victims that we want to protect and make sure their rights are upheld over the rights of the offenders. And so I guess I just wanted to paint the picture that this is not a new problem that we're trying to solve. It's been years and decades in the making, and I think we're all committed to this to make sure that we can reduce incarceration rates, especially for Aboriginal people, because the numbers are so high, but that we need to continue that work and find other ways. But like I said right from the outset, our priority is making sure people are safe and reducing crime.
Thank you, Attorney General.
I'll now hand back to Member for Mulga.
Thank you. Through the Chair to the Minister. Here. The Aboriginal Justice Agreement also aims to support Aboriginal leaders. Can you outline what is in this budget to meet this aim? What policies and processes support Aboriginal leadership?
Thank you for the question, Member for Mulga. And yes, we have also always said that we want to engage with Aboriginal leaders to help us drive down the incarceration rates, and you know, to support us addressing the root causes of crime. I might hand over to Mr. Pocock, who is the Director of Aboriginal Justice Unit, just to talk through some of the things under the Aboriginal Justice Agreement and the leadership who they've been working with across the Territory.
Thank you, Minister, and thank you, Member for Mulca. Robert Pocock, Director of the Aboriginal Justice Unit. So in terms of supporting leadership of Aboriginal people in communities, I guess the key focus in this budget has been through the ongoing funding of community courts and then the rollover of funding in relation to law and justice groups of current NTG funding and the negotiation of funding for additional groups through the Northern Territory Remote Aboriginal Investment Agreement. As you'd be aware, Member for Mulca, law and justice groups and community courts are about supporting Aboriginal community leaders to, I guess, take a stand and be at the forefront of justice in their communities. The funding they receive supports training for law and justice group members, the ability to visit other law and justice groups to learn from them, and I guess allow for participation in the justice system through community court by elders within the community. And as you'd be aware, in the communities in East Arnhem, so at Groot and Ramingining, and then at Managruda as well, community court's been operating, and there's been, at least at this stage, sort of anecdotal feedback from the groups that there's been great uptake by the community in the law and justice groups and the community court process, and I guess a raising of elders in that process in terms of they're being seen as having responsibility and authority in the justice process, which wasn't necessarily there prior to these initiatives. So I think some examples from the group at Kintor, you've had elders who have been given sort of supervision of young offenders in community to be able to make sure that they're complying with their orders, and that's building that respect and giving that responsibility back to community leaders. And if the kids aren't complying, or adults as well, those elders have the ability to notify the court of non-compliance and work in terms of what options are for the court in dealing with that.
Through Chair, the question to the Minister. Are there any Aboriginal community-controlled programs running out on country for early intervention, prevention, diversion, or alternatives to prison that come under the autonomy, that come under Attorney General Department? Because, I'll read that again, comes under the Attorney General Department. Please provide where the programs are, the organisations and the funding amount they receive.
Thank you, Member for Mulca. So under the Attorney General's portfolio, we do have the alternatives to custody, which we have talked about today, one in Groot Island and one in Alice Springs. Of course, there are programs that do sit under corrections, and there are early intervention arrangements and programs that sit under children and families, so they're sort of outside my portfolio, so to speak. But I'll just check to see what other ones I'm missing. Give me one moment. I might hand over to add to this to Janet. Do you want me to hand to you or Robert? Oh, Robert. To Mr. Pocock to add to that answer.
Thank you, Minister. Thank you, Member for Mulca. Robert Pocock, Director of the Aboriginal Justice Unit. So in terms of the law and justice groups, there are some of them which run their own programs out in community. So I think the primary one being the Marie-Clare MLA Law and Justice Group has been for some time now running a youth justice program and a number of youth programs, and that's supported work through the Law and Justice Group. And there are other law and justice groups which are operating, which are in the process of developing programs for youths. For example, the group at Kintor is looking at establishing a program to get problem youths out of town and into outstations for some time out from community where they've had behavioural issues, for example. But I don't have any further sort of specific data around the programs that each of those groups are running on me presently.
Thank you, Minister. Through the Chair, I'll ask the last one that should be mine done. As the first law officer, I understand the Attorney General provides legal and policy advice to the government on human rights matters on the 13th of May. In the chamber, you stated if you do the crime and assault someone, we are not worried about the trauma you may have by being in the watch house or at the correctional facility. But half the people in the prison are innocent until proven guilty because they have not yet been convicted. And as the Attorney General, your job is to uphold the rights of everyone, including prisoners. What advice is your office providing to the government to, in relation to the treatment of the anti-prisoners? Right. Thank you.
Thank you, Member for Mulca, for the question. I stand by my comments that if you are caught breaking the law, especially some of those serious violent offences which hurt other people, then if the police arrest you and you find yourself before the court and you have to wait for your court date incarcerated, then that is what has to happen, because we cannot accept the level of violence in our community, and we must deal with those who are offending it to make the Territory a better place, because those levels of crime are just unsustainable. Also, we haven't just these problems we have with numbers of people in remand and days in remand haven't just appeared overnight. It's been a long time coming. It's a terrible state of affairs that we find ourselves in, and I look back and think, well, that's because over nearly a decade we've had no accountability or consequences, or very little accountability and consequences for offenders. The rights of offenders, time and time again, were put above the rights of victims. And, we were elected to a new government to change that. And that's exactly what we have done. We still have a huge mess to clean up. But in the short 10 months that we have been in government. We've made a lot of changes, and there's some things, the impact of that is incremental and small, and even the days of people on remand is quite small. I think it's a slight decrease of the number of days in remand in our court system now compared to what it was. But we will continue to make the changes that are necessary to make our community safe and reduce crime. And, you know, I sort of question anyone who's thinking about the trauma that is caused by being incarcerated. You know, what about the trauma of the victim? The victim has gone through something horrendous, and, you know, those people who have perpetrated their crime on the victim does need to be held to account and face a court, and for a system to determine whether they are guilty or not, and if they are guilty, a consequence for that.
Member for Johnson.
Thank you. Follow up. So thank you, Attorney General. So just to confirm, you're not worried about the trauma that someone may have by being in a watch house or a correctional facility, knowing that two people can have trauma at the same time. And as the member for Malka said, your job is to uphold the rights of everyone, including prisoners.
Member for Johnson, thank you for the question. My priority lies with striking and changing the balance, I guess, from where we were to putting the rights of offenders above the rights of victims.
Through the chair, I'm just interested in a yes or no answer. Thank you, Attorney General.
Thank you, Member for Johnston. It's not really a yes or no question that I can answer. I think it deserves the explanation in terms of the fact that Territorians, law-abiding Territorians, are our priority next to victims of crime that have been perpetrated against them. And, you know, watch houses, corrections facilities, whilst neither of those are in my portfolio, they are a place for people to be held until they face their court or they face their sentence in some cases. And then, of course, they go through a rehabilitation. And that whole system has been breaking under a huge mess, which was not created in the last 10 months. In fact, we're working to try and solve the problems that we have in the Territory. And so I will keep doing that work, and I will keep putting the rights of victims above the rights of criminals.
I have further questions, but in the interest of time, I'll move on. I just have one last question, which is that under the Aboriginal Justice Agreement, under this output, under the Aboriginal Justice Agreement, part of the agreement says that it will revisit and review relevant reports, inquiries and recommendations from royal commissions. So this would include reviewing the Aboriginal deaths in custody recommendation that police don't investigate police deaths in custody. Will this government, through the AJA, support an independent inquiry into 𝙍𝙀𝙇𝙀𝙍𝙍 White's death?
Thank you for the question, Member for Johnston. Our government has been very clear from that moment in time, the tragic incident, and it's a very sad time for a lot of people in our community, but we have been very clear that we won't interfere with that investigation. That is going to take its course. The police will do their investigation, the coroner will do her investigation, and then the outcomes of those will be presented to government, and we will look at that then.
We will now take a 5-minute break. This will be the last break of this session, so please utilise it if you need. Time now is 2:09. We will reconvene at 2:14. Are there any final questions in Output 2.3? That concludes consideration of Output 2.3 and Output Group 2. I now call for questions on Output Group 3, Justice Services, Output 3.1, Higher Courts. Are there any questions? That concludes consideration of Output 3.1. The committee will now consider Output 3.2, Lower Courts. Are there any questions? Member for Johnston.
Thank you. I'm not sure, does the do specialist courts fit under lower courts? Yes. Okay. Attorney General, in Action Plan 2, funding was provided for the Specialist Domestic Family Violence Court in Alice Springs and provided for developing training. Can you advise what the outcome was of that funding? In Action Plan 2, it says that it was to develop training and deliver it to judges and legal services.
Thank you for the question, Member for Johnston. I can confirm the local court received additional funding in the 25-26 budget for activities associated with the Domestic Family Violence Court, 1.068 million in 25-26, 9.598 million over 5 years and 2.554 million ongoing. That funding provides support for the existing Alice Springs Specialist Court, including the employment of a registrar, legal support workers, non-legal support workers, legal training and program evaluation. The funding also provides for expansion of the Domestic Family Violence Court to 2 or more sites in 27-28.
Thank you, Attorney General. I'm specifically interested in the outcomes of the funding to develop training.
Thank you for the question, Member for Johnson. I'll introduce Mr. Chris Cox, PSM, and the Executive Director of Justice Services with the Attorney Generals, to add to the answer.
Chris Cox, Executive Director, Justice Services. We're currently developing a training plan for that budget. So we received a specific allocation this year. We're currently working with the Project Control Group now to roll out that training. So the training will be for judges and for lawyers.
So that allocated funding is still existing and will be done. Thank you.
Yes.
Thank you, Mr. Cox. I also note that $0.6 million was provided to AGD for funding legal services to provide representation as part of the specialist court. Can you advise what legal services that funding was allocated to and what date the grants commenced?
Thank you for the question, Member for Johnson. We just don't have that level of detail, but we're happy to take it on notice.
Thank you.
Member for Johnson, please restate the question for the record.
In Action Plan 2, funding of $0.6 million was provided to AGD for funding legal services to provide representation as part of the Specialist Domestic Family Violence Court in Alice Springs. What legal services was this funding allocated to and what dates did the grants commence?
Attorney General, do you accept the question?
Yes.
The question asked by the Member for Johnston of the Attorney General has been allocated the number 5.11. Member for Johnston.
Thank you. Also, in Action Plan 2, $180,000 was allocated to AGD to undertake an external evaluation of the Domestic Family Violence Specialist Court. Has this evaluation occurred?
Thank you, Member for Johnson. I'll hand to Mr. Cox, Executive Director of Justice Services.
Thank you for the question. We're currently developing an evaluation plan, so there'll be an evaluation during 25-26.
Thank you. And just to clarify, that money put aside for that will be used for that evaluation plan?
Yes, that's correct.
Yep, thank you.
Yep.
Just a couple more questions. Thank you, Chair. These are questions about the Coroner's Court. Does that come under this output as well?
Yes,
Thank you. So under the NT Coroners Act, I understand that if the coroner makes recommendations to a CEO of any agency, they must provide a response within 3 months of receiving the recommendations from the Attorney General. Noting that the coroner handed down her report into domestic family and sexual violence death, which included 35 recommendations to a number of agencies on the 25th of November 2024. What date were agency CEOs informed of their recommendations by the Attorney General, and when did the agencies respond?
Thank you for the question, Member for Johnston. I just want to clarify, it definitely was the DV coronial that you're referring to, because I've got that information here.
Thank you.
On the 25th of November 2024, the Territory Coroner, Judge Elizabeth Armitage, wrote to the Attorney-General, myself, under Section 35 of the Act, forwarding a copy of the coronial findings regarding the deaths of Mrs. Rabancha, Haywood, Yinupingu and Rajuk, that the deceased persons. I wrote to the CEO or commissioners of the following agencies requesting a response to their recommendation relevant to the agencies, so Department of Chief Minister and Cabinet, Department of Children and Families, Department of Health, Department of Corrections, Attorney General's Department and Northern Territory Police. The Department of Children and Families coordinated a whole of government response to the domestic violence coronial, incorporating input from other responsible agencies. The response has been finalised. I received the final agency response in mid-May, and under the Act, the next steps is to report on the coroner's report and recommendations and the agency responses to the coroner's report and recommendations. With the timing of the final response, that particular report wasn't ready for the May sittings, but we are now working closely with the Department of Children and Families to complete the full report for tabling in the next sittings.
Thank you. So given that it's 7 months since the recommendations came down, the expectation is that it will be tabled in the next sittings?
Yeah, so it will be tabled, but I might add that a lot of the work that the recommendations highlighted have already begun through the agencies. So once, obviously the response will be tabled in the next sittings, but that we've obviously had lots of commentary around the recommendations and a lot of discussions as well in Parliament about the things that we have already implemented based on those recommendations.
Thank you.
Yep, member for Blaine.
I have a follow-up question about the Coroner's Court, if I may, under this output.
Yes, Coroner's, yes.
Yep. So we've had a few high-profile and very important coronials over the last few years. I was just wondering if you have any information about how much they might have cost compared to, say, the median cost of coronials previously. So specifically the Walker coronial, the domestic violence coronial that we were just talking about.
So I will hand over to Mr. Cox to answer from. Okay, yeah. I will hand over shortly, but I guess can I just. Yeah, I might hand over to Mr. Cox to answer that question.
Chris Cox, Executive Director, Justice Services. The Walker case. Sorry, can I just ask? Can I just ask what the question is again?
Sorry, so I'll restate the question for you. Just curious how much the Walker coronial and the domestic violence coronial cost, and then potentially you could look at what the average of the other coronials is, because they're very important coronials and we've invested quite significantly in them.
Is it possible, just going off the Attorney General, is it potential, how many coronials have been done in the reporting period?
Yes, I have that data. 2 seconds. Mr. Chair, we might have to take both questions on notice, so you might want to do it one after the other. Oh.
Yeah, I can answer for these two.
We'll take it on notice. Member for Blaine, are you happy to add my part into your question? Being how many?
Yes.
Okay. Member for Blaine, please restate the question for the record.
How many coronials? I'm sorry. We need to clarify this. Are we looking at all coronials that are covered by the reporting period because they would start before and finish after? Are we talking about just the ones that were completed within the coronial period? Is that what you're after?
It's your question. You can
All right.
ask
We'll say completed during the reporting period. Okay. How many coronials were completed during the reporting period, and how much did the Walker coronial and the domestic violence coronial cost? And if you could include the median cost of other coronials in the reporting period for reference.
Attorney General, do you accept the question?
I do.
The question asked by the member for Blaine of the Attorney General has been allocated the number 5.12. Member for Blaine, do you have any further questions?
Just one follow-up question from my earlier question, if that's okay,
Member for
Chair.
Johnston, of course.
Thank you. Attorney General, I think you said you'd got the response from DCF in May. Is that? Sorry, I'm going back to my question about the response to the coronial recommendations.
I just have to go back and check my notes again. Member for Johnston. Yes, member for Johnston, I received the final agency response in mid-May, and as I said, we didn't make the cut-off for the May sittings.
Would it be possible to get a copy of that response?
That's what will be tabled in the July sittings.
Or will it be your report that's tabled in the July sittings?
It's my report, and it includes the agency's recommendations.
So would it be possible to get a copy of the report prior to the to the next lot of sittings?
That particular part of the response is owned by the Department of Children and Families, so I can't answer on their behalf, but the response will be tabled in Parliament in July.
Okay, so it could be a question to the minister, the relevant minister?
Yes, I believe she's on
thank you.
tomorrow.
Thank you.
Are there any further questions in Output 3.2? That concludes consideration of Output 3.2. The committee will now proceed to Output 3.3, Anti-Civil and Administrative Tribunal. Are there any questions? That concludes consideration of Output 3.3. The committee will now move on to Output 3.4, Registrar General. Are there any questions? That concludes the consideration of Output 3.4. The committee will now consider Output 3.5, Parole Board. Are there any questions? That concludes the consideration of Output 3.5 and Output Group 3. I will now call for questions on Output Group 4, Director of Public Prosecutions. Output 4.1, Director of Public Prosecutions. Are there any questions? That concludes consideration of Output Group 4. We'll now move on to consider Output Group 5, Independent Officers. Output 5.1, Anti-Discrimination Commission. Are there any questions? Yes, we'll rest in place for 1 minute and allow the staff to change over. All right. Output 5.1, Anti-Discrimination Commission. Are there any questions? Opposition?
Thank you, Chair. Attorney General, why was its funding subsequently reduced from 1.924 million in the 2024-25 to 1.655 million in the 2025-26 period?
Thank you, Member for Daly, for the question. So the Anti-Discrimination Commission has a decrease overall of $269,000. $240,000 of that decrease is due to the finalisation of short-term funding reallocated from within the Attorney General's Department budgets for volume. $50,000 is due to the finalisation of sexual harassment bystander training that was delivered in partnership with the Department of Children and Families. And there's an increase of $21,000 in NTG parameters.
Is that
Member
all right,
for
Chair?
Nycliffe?
Thank
Yep.
you very much. Oh, sorry, no.
All right. We'll allow Member for Daly to... Yeah, Member for Daly.
Thank you, Chair. Sorry, Member for Nycliffe. Just a question for the Commissioner, if that's okay, Minister. Did the Commissioner request additional resources to manage the anticipated increase in workload due to recent legislative changes?
I'm happy for the Commissioner to answer that question.
Thank you, Attorney General. Thank you, Member for Daly. Yes, we did put a request for additional funding, for additional resources as a result of the reforms that have come to our Commission, but also in relation to ongoing need for complaints officers to manage the backlog of complaints that we have at the Commission.
Thank you. And was that request met?
Member for Daly, can I just add to the Commissioner's response? The reason we gave that top-up funding for that short-term allocation was for exactly what the Commissioner describes. I should say, was it the 240? 240. The 240.
Can I just clarify?
Yep.
Thank you. Thank you, Attorney General, and thank you, Member for Daly. So the additional $240,000 was not meant for purposes of the resourcing needs in relation to complaint officers. That was a contingency fund that was put to the Commission in relation to operationalizing some parts of the new reform. So, for example, we needed to build capabilities of our own staff in relation to the positive duty reform that came in. So we used some of the funding from there for that purpose, but none of that funding was for purposes of the long-term needs in relation to additional resources of complaints officers, but also then the long-term needs in relation to operationalization of the new reforms that had come to our Commission, especially in relation to positive duty. So the answer would be no.
Thank you, Commissioner. How will the reduction in funding impact the Commission's capacity to effectively handle complaints related to disability, sex, racial discrimination, which your 2023-24 annual report identifies have significantly increased? Thank you.
I'm happy for the Commissioner to answer that question.
Thank you, Attorney General, and thank you, Member for Daly. So without the additional funding, that has clearly provided a backlog resourcing issue for us in terms of the number of complaints that we have. So we manage up to about, say, 300 complaints that's handled every year. So at the moment, with only 2 complaints officers, which their load is about 30 to 40 cases a year, that has put a real wedge in terms of managing the ongoing matters at the Commission. So the reduction, but also what was requested in terms of additional funding that has not come to the Commission has clearly created a greater backlog for us in terms of complaints at the Commission that we're handling at the moment.
And I'll just add to that as well, Member for Daly, that the positive duty legislation that was introduced in 2022, the former government hadn't put forward any funding for that either, and of course that now just continues on.
Thank you. Through the chair, given the rise in racially motivated incidents and hate speech nationwide, do you consider the existing NT legislative framework and protections adequate for effectively responding to and preventing racial vilification and discrimination?
Thank you, Member for Daly. Just to clarify, I think you might be asking the Commissioner for an opinion.
Thank you, Attorney General. I will uphold that. It's just that it's an opinion of the Commissioner. If you can rephrase it in a way that he can answer, just without giving an opinion.
Thank you. Okay, so does the existing NT legislative framework and protections adequately or effectively respond to preventing racial vilification and discrimination?
Thank you, Member for Daly. So the current version of the vilification provision in relation to Section 20, capital A, is sufficient for our purposes in terms of meeting the needs of vilification here in the Northern Territory. So hence why there was no need to look into amending it or repealing it for that matter. So from the Commission's perspective, the current provision in Section 20A is sufficient.
Thank you.
Follow-up question, Member for Johnson.
Thank you, Minister. Can you advise, I think these were questions that you suggested we put when the Commissioner was here, since in the reporting period, how many vilification complaints have been received by the Commission?
I'm happy for the Commissioner to answer that question.
Thank you, Attorney General. Thank you, Member for Johnson. To date, the statistics that we have show that we've received about 46 vilification matters at the Commission.
And how many of them were accepted?
So out of the 46, so if you're looking at this financial year, let me just check my notes, please. For this financial year, the vilification complaints accepted, it's 3 out of the 46.
3?
Yes.
Thank you. How many were conciliated?
The number conciliated 0 to date.
Okay, thank you. And can you outline what protected attributes the complaints were in relation to?
Sorry, could you please repeat the question,
Which
Member?
protected attributes the complaints were in relation to?
So thank you, Member for Daly. So the protected attributes vilification complaints were in relation to race, religious belief or activity, gender identity, and disability.
Thank you. And how would the Commission generally handle those complaints?
Thank you, Member for Johnson. That's a good question in terms of how we handle the complaints. So generally, when we receive a complaint coming within our case management system, we first put it through a process where we consider whether it is trivial in terms of or vexatious or has no ground. So that goes through the usual complaint management process. Once it's gone through that process, then we consider the substantive law elements in relation to vilification in Section 20A. So that requires us then to look into not a subjective standard, but an objective standard. That needs to be made really clear. So it's an objective standard that we apply, not a subjective standard in terms of how we assess it. And we clearly apply jurisprudence in relation to the vilification provision in using provisions that come from either the Commonwealth position or other jurisdictions that use similar principles.
So if, for example, I was offended by this glass of water, that would not be taken as a complaint?
That would not be taken as a complaint. Also, it's important to note that these vilification complaints are only in relation to statements that are made in public, and the threshold for assessment is a high threshold, not a low threshold. And this is why it's a job of the Commission through the first assessment process, from a complaints management perspective, from looking at it whether it's trivial or vexatious, we then put it through the substantive law element. So things like your jokes at the pub, etc., would not amount to vilification in the context of the way in which we assess it, a mere joke in itself. Clearly, if that joke is one that incites hatred in relation to one of the 24 protected attributes like race, gender identity, disability, then that would be something we need to consider. But again, it's based on an objective standard, not a subjective standard in relation to someone just feeling precious about the matter.
Okay, thank you. So in relation, I understand you've seen a copy of the new bill, is that correct?
No, I've not seen a copy of the new bill, Member for Johnson.
All right, okay. Given what you know of it in the public space, do you feel that it's going to assist with your work? That may be an opinion.
Yeah, I think that's just a straight opinion. If you can you rephrase?
The member for Nightcliff might be able to. Have you got a follow-up question, or is it a? It's not a rephrasing, it's a follow-up. Okay, so given what you've outlined in terms of how you currently investigate complaints, the fact that from what I heard, only 2 of the 40 complaints that were made to the Commission actually were accepted. Is that
3?
3, sorry, 3. Do you? Oh, it's an opinion question too. From the perspective of the Commission, are there needs to strengthen that Act? That's not really my question.
We're going to opinion again.
Sorry, my question is, you've just given us some very useful information. Thank you, Commissioner. And I think it's very useful in terms of what we're talking about in relation to potentially change laws. Just wondering how we take that information into account and whether it's been taken into account in the development of the new laws.
Thank you, Member Johnson. The current version of Section 20A, the vilification provision, I think is one of the strongest pieces of vilification law that's already in place. It's highly visionary in terms of where we were going with that reform. And I think it's one that, and perhaps this is an opinion piece, but it's one that we need to protect here in the Northern Territory. Any other version of the vilification provision would be watering it down. What we say at the Commission is that the current version holds, and it's the strongest piece of vilification law that we have here in Australia, and there's no need for further amendments to that provision.
I'll just add to that, Ms. Member for Johnston, that just to be clear for having the Anti-Discrimination Commission next to me, the decision on the changes to the current Act is based on government policy. So we're out listening to the community. We've now taken steps based on that information, and that will be, of course, brought forward to Parliament in July, like I've already said. So I just wanted to make that really clear for the committee and for yourself. Thank you.
Thank you. But based on the data that we've heard, currently vexatious complaints don't come. The Commission, that's not part of the Commission's work. They may come there, but you don't do anything to.
Member for Johnson, if the matter is a vexatious matter, and that's the first point in which it sieved through, and it doesn't progress further, I think it's important to also just note from point of clarification here that the current Section 20A is drafted with the words offensive behaviour, and taking note that there's some unease in terms of the reference to the word offensive behaviour. However, it must be noted even the Section 37A that is being considered now for reenactment also has the offending provision in it. So it's interesting to note that there is a different view in relation, and the unease in relation to the use of offensive in one provision where it's in relation to one protected attribute, which is religion, but not the other, which applies to all 24 protected attributes.
Can I just add that we are talking about like the budgets and the output, and this is a government policy position. I went through a lot of stuff in detail this morning, and of course it still does have to be introduced into Parliament. We aren't at that stage yet.
Yep, I have a follow-up question in relation to the vilification matters that have come before. So 46 and only 3 have been accepted. Can you please give us an idea of how much time, resourcing and money was spent on disregarding the remaining 43 that weren't accepted? How much resources does that take for the Anti-Discrimination Commission to actually clear and say there's no argument here?
Yep, I might have to take that on notice because we don't have stats or collect data in terms of how much time has been spent on matters that, are you saying that we have not considered?
I'm assuming there's a process that you undertake to be able to disregard those matters and actually then provide a response and saying we're not taking on these matters. I'm just wondering how much time and resources that takes. I'm happy to take that on notice as well, but if you could give an idea of how many hours each complaint takes just to understand whether or not you're going to accept it or not.
Thank you, Member for Fanny Bay. So generally speaking, by way of the legislation, it's within 3 months. But because we've got a backlog of cases, we've now put to many of these new complainants that we can only allocate it after 6 months, if at all. So in terms of answering your question, from a general perspective, it would be 3 months.
So that's a required response time. I'm just wondering if you have a staff member that receives a complaint, how long does it take them to assess whether or not it's accepted or not? Does it take a day, a week, a month for them to assess all the components to determine whether or not it's accepted?
Thank you, Member for Fanny Bay. So it depends. Every matter has a different complexity to it. So there isn't a straightforward answer to your question. Generally, once the matter has been allocated and the parties and the wheels of that whole process go into play, it would take between, say, 3 months to 6 months. But it really depends. So it's not a straightforward answer, Member for Fanny Bay. But if you want, we can do some case studies for you and take that on notice.
Would you like that? Would you like some case studies on notice, Member for Fanny Bay?
Yeah, I'd just like to, I can restate sort of in a way.
Okay. Member for Fanny Bay, please restate the question for the record.
Thank you. If the Commissioner could please provide an overview of, out of the 46 cases that were presented, 43 were declined or not accepted as a suitable case. Out of those 43, how long does it take and what's the resourcing and the financial cost to determine that they weren't acceptable cases to take? Does that make sense? You can give an overview. You don't have to give necessarily specific case studies, but I'm assuming that staff take time on each of those 43 cases and resources go into determining that that's not an acceptable case.
Thank you, Member for Fanny Bay. Look, I think clearly if the cases were one that has been not accepted based on the first sieve, which is the fact that it was frivolous or vexatious, then it's going to take very minimal time. But we're not talking here about the 43 cases. There are over 300 complaints that are not vilification related, but discrimination related as to the reason as to why we're requesting for more resourcing and funding. Clearly, with the 43 vilification cases that were not accepted, it also had to go through its own process in terms of verification, but also case management. And I would think, I can't give you a number in terms of how long it took, because each one of them would have taken a different period of time. In terms of the resourcing and funding that has been put into each one of that, in those cases, clearly, as you know, we've only got 2 complaints officers in our at the Commission. So it's really time costs that we need to sort of peg against an AO7 and AO6 who are managing those matters.
Yeah, so it'll be Member for Nightcliff next. I just want to clarify. Do you have a question on notice?
I would like to get an understanding of the cost involved for cases that don't progress, whether it's vilification or it's discrimination. I would like to get an understanding of the kind of resources that go into determining that something is not suitable for following through on.
Member for Fanny Bay, it may be best if we take that question on notice.
Yeah, that's my question.
So, Member for Fanny Bay, please restate the question for the record.
Thank you. Can the Commissioner please provide an overview of the cost involved in cases that do not progress regarding resources and financial expenditure? Thank you.
Thank you, Member.
Attorney General, do you accept the question?
Yes.
The question asked by the Member for Fanny Bay of the Attorney General has been allocated the number 5.13. I do note Member for Johnston, but I will give it to Member for Nightcliff and then come back to...
Sure, go.
Okay, Member for Johnston.
Better be tiny.
Member for Johnston.
She's pushy, politely pushy. Attorney General, this is a question for the Commissioner. I note in your media release, you said that you'd consulted with the Commissioner in relation to the changes. My question is, what were his recommendations?
Thank you, Member for Johnston, for the question. I think I spoke about this earlier today, but basically before the election and in 2022, we, in particular Section 20A, we were talking about repealing the whole section.
Sorry,
but when I met with the Anti-Discrimination Commissioner, we had really good in-depth conversations about the fact that if we did remove that altogether, a full straight repeal, that there might have been some unintended consequences for making that policy decision as a government. So those conversations are valued, and we took on board the information and feedback, and of course we've now come forward with an amended version of the not repealing Section 20A in its entirety, keeping it there, but just altering the words.
Are you, through the chair, are you able to share his specific recommendations?
I think I might have also answered this earlier today to the member for 𝙍𝙀𝙇𝙀𝙎 question in relation to those meetings that were held were face-to-face meetings in my office, and so I am not aware or can recall any documentation around it. They were face-to-face meetings.
Is the Commissioner able to answer that question?
I'm happy for him to answer the question about the
His
feedback he gave me.
Thank you, Attorney General, and thank you, Member for Johnson. So our recommendations was, number one, to retain the current version of Section 20A and Section 20B, and number two, not to revive or reenact Sections 37A. In relation to Section 37A, the recommendation was also that it was legally redundant because to date there are no matters that have been, at the time of which it was repealed, or the historical reference to Section 37A, there's been no cases brought in for exemption at the Commission. Also, there are other provisions that are already providing exceptions in Section 35 of the Anti-Discrimination Act and also in Section 51. So there wasn't a case for a need for another exemption that then impacts certain attributes like sexuality and other religious beliefs.
And like I said, Member for Johnston, we're now, we were already consulting in the community, and part of that consultation was with the Anti-Discrimination Commissioner. And of course, that consultation will continue now that there has been those adjustments. And because we are indeed out listening to the community right across the territory in different groups of things that people enjoy.
Can I just get to my questions?
Yep. Member for Nightcliff.
Thank you. Through the chair, so just to clarify from what we've heard here, in terms of 20A, there was 46 complaints, only 3 were accepted. It's an objective standard, not a subjective one, with a very high threshold, and this goes against the recommendations of the Commissioner. So it's fair to say then the idea of people getting in trouble for cracking jokes at a barbecue is just factually incorrect under the current standard. Is that right?
Thank you for the question, Member for Nightcliff. No, that is not entirely accurate because the standard is of an objection measurement of how a person feels about a statement it's emotional. So it can't actually be
but not
subjective.
It's
based on common law. It's based on case law, and there's plenty of cases. So therefore, it is actually subjective in its very nature.
Okay. Thank you. I'll just keep moving with the time. So you are intending to reinstate the 37A of the Anti-Discrimination Act? That's confirmed? Is that confirmed?
Not in its entirety. We have inserted a new section which will be introduced in the Parliament in July, and basically it's not exactly how it was. What we've done is included protections for religious institutions so that they can continue to hire people of faith base without finding themselves in court.
Thank you. So on that, we already have provisions that protect occupational needs in Section 35, right, which balance religious freedoms with the rights of other. So the point has been made that reintroducing these things in 37A is redundant, legally confusing and symbolically harmful. Why is your government misleading people by saying there is no provisions for religious freedoms in hiring when there is in Section 35?
Thank you for the question, Member for Nightcliff. So I will I'll state again what I have been saying most of this morning about these particular changes is we promised the community that we would make these changes, and we are now putting in place those protections because we absolutely believe in religious freedoms and being able to continue to teach their faith in faith-based
Which they
institutions.
already have, though, under Section 35, right?
Committee, Attorney General, Member for Nightcliff,
right.
yeah, just come to me.
There's
if
time,
you,
I know, and the time is
so
ticking. Okay.
If your question's answered, just say,
Okay.
Chair, I think the question's
Right.
answered.
Thank you, Chair. I think the question's answered. So reinstating this religious exemptions under Section 37A would permit religious schools to discriminate against staff based on sexuality or beliefs, correct?
So thank you for the question, Member for Nightcliff. The changes are not exactly the same as what they were. We have not referred to any attributes in that part of the Act. What we have said is that they can now hire based on faith, and that if there are any cause for future issues, that it cannot be based based on attribute. It needs to be based on conduct. So, for example, if there's some problems in the workplace, they cannot discriminate against an attribute. They can only discriminate against as conduct.
I think my question's answered.
Okay, thank you. Attorney General, if you can briefly sum up, because we won't, but otherwise we'll go to the next question. Do you have anything else you'd like to add?
I've answered the question.
Okay. Member for Nightcliff.
Oh, no, that's all.
All right.
I want to move on.
Member for Fanny Bay.
Thank you. I just wanted to check, I guess, possibly through the Minister to the Commissioner, how long have you been advocating for additional funding for the Commission for?
Thank you, Member for Fanny Bay. I've been advocating for additional funding since I got into Commission in August 2023, and I believe that advocacy is one that my predecessor was also advocating for prior to that.
And do you have any reasons as to why that was declined in the past?
Yeah, so if it's not in this reporting period, I don't think we need to.
Sorry, Chair, it was in this reporting period for
Okay.
some of the requests that we've put for additional funding. My understanding was that because there were other priorities, and I think there's a need to understand that we are doing frontline services here also at the Commission. So the response was that it was meant to be diverted to or prioritized to other frontline services, when in fact the Commission's work in discrimination, sexual harassment and victimization are very much frontline services work too.
Thank you,
I might
Commissioner.
add to that if I can, Member for Fanny Bay. And I can't speak for the past government, but in our new government, of course, we were inherited a very large debt, but also operationally there's not a lot to go around, and so we had to do the reprioritisation and focus on things like the local court, like the DPP, like legal aid, and so the budget bids from the Anti-Discrimination Commissioner, it was a policy decision of government of reprioritisation. We couldn't make all the money go around to all of the places that are needed, and we certainly had to make that tough decision and invest those funds into those very broken systems, which I've spoken about today as well.
Thank you.
Are there any further questions on output 5.1?
I've got a tiny follow-up. I just wanted to clarify to the Commissioner through the Minister. Did you say that there haven't been any complaints under what will now be 37A in the past?
Member for Johnson, so yes, there haven't been any complaints. Clearly, that provision was repealed in the previous financial year. And even in the previous financial year, historically, there were no complaints from my knowledge since I've come in as Commissioner in August 2023 in relation to Section 37A.
Do you know if there were any prior to your time?
I believe from what we've done in terms of the data mining, just preparing for this, there has been no cases that I am aware of.
Okay, thank you.
That concludes the session. On behalf of the committee, I'd like to thank all of you for being involved, and thank you, Attorney General, for attending and appearing before us today. Final points, because I know I like giving my stats. So in today's session, in 309 minutes of question time, government questions were 20 minutes, which was 6.4%. I am pleased to let the member for Guyula know he's officially off his warning and look forward to him rejoining the committee. The committee will now take a short break and resume at 3:30 p.m. with questions of Minister for Education and Training. Attorney General, I'll hand over to you for any final comments and thank yous.
Thank you, Mr. Chair, and thank you to all the committee members. And I thank the officials that joined me at the table. I am sorry we didn't get to many of the outputs and including a whole other agency and portfolio, but I know the work you do is so beneficial for the whole of the territory. So thank you for all that work that you've done and the work that you will be continuing to do under the portfolios.
Thank you, Attorney General. And on behalf of the committee, I would like to put a big special thank you to Tourism and Hospitality and Territory Wildlife and Parks for what I know would have been a huge body of work in preparing for today. And unfortunately, we couldn't get to them, but the committee gives our sincere thanks for that work. Thank you.